May I please, may I please, Your Lordship? Lordship, my sincere apologize. Since the council handling this matter, he is on leave.
Who?
Tipapom.
Item one.
1 and 2, Lordship.
1 and 2.
You mean, okay, this is the only matter for DB.
Yes, Lordship.
We have fixed it today specifically.
Lordship, his name also reflected in the leave list, Lordship.
Let us hear him a little bit.
Yes, Lordship.
Will we?
Lordship.
let us-
Lordship, I pledge.
Yes, what is their case?
Yes, Lordship. Cuối cùng hốt vào just from your Maybe, Lordship. Lordship, the President read the appeal. This has been filed challenging the judgment in order dated 4/3/2022, passed by the learner single judge in WBC number 176 of 2019.
Writ petitioner is not an indigenous inhabitant.
No, the private respondent number 4.
That's the writ petitioner.
Read petitioner in Lordship, yes, Lordship, in the read petition. Lordship.
In the writ petition, she is the writ petitioner. The respondent number 4 hearing is the writ petitioner. Correct?
No, it's a read petition. Yes, Lordship.
So now you, according to you, she is not an indigenous inhabitant.
Yes, Lordship.
Why?
Lordship, the state government issued a notification that is in the year 1977. Lordship, as per this notification, in order to qualify as an indigenous inhabitant of Nagaland, a person has to qualify 3 conditions. Lordship, when my writ petition was dismissed by this learner single judge, the writ petition filed by the respondent number 4, that was also heard together. Lordship, what happened was like this. When my writ petition was pending, challenging her indigenous inhabitant certificate, the district administration of Pukuputu has issued an order cancelling her indigenous inhabitant certificate.
That cancellation. The issue is, why do you say the writ petitioner is not an indigenous inhabitant?
Yes, Lordship. Lordship, the present private respondent, he has not qualified the condition as prescribed in this 1977 OM. Inquiry was conducted.
That is made by whom?
OM is made by the state government, Lordship.
State government.
Yes. Lordship, we can come to the OM. That is at page number.
So that is the basic case.
That is my basic case.
The basic case that the 1977 OM does not
Qualify her.
Does not qualify the writ petitioner to be an indigenous.
Indigenous inhabitant.
That's your case.
That's my case, Lordship. And Lordship, the
Oh, yes, do that.
Please, your lordships. Lordships, my contention is, of course, 1977, it lays down some criteria for to be qualified as an indigenous person. However, in addition to this notification, lordship,
In addition, first of all, is your case covered by all the within the 4 corners of the 1977 notification?
no, lordship, admittedly, no. Lordship, a similarly situated person, a precedent has already been set. A similarly situated person, lordship,
Two wrong, don't make a right. A precedent which is not in terms of the guidelines or the OM, which is not under challenge, does not give you any right. What remains, why did the single judge allow your writ petition?
lordship,
Lordship, the legal single judge allowed the writ petition directing for inquiry.
That is the following.
Inquiry was conducted.
Okay, an inquiry.
Inquiry outcome is she studied indigenous independent.
So why are we sitting here? So what
lordship,
is this writ
in my writ petition, I'm challenging that inquiry proceedings, lordship.
petition?
That inquiry is arbitrary, inquiry is unjust, because there is a gross violation of principles of natural justice also, lordship.
So, in the writ petition, now this is a writ appeal, no?
Lordship, the writ appeal is filed by me. My writ petition was dismissed on the ground that since I participated in the selection process, now I cannot turn around and challenge the selection. That was
That is wrong.
that is the principle is totally wrong. That is what I am challenging, Lordship. Lordship.
Lordship, during the pendency of this writ appeal, the decision of the inquiry
Has been-
that, yes, has been made. It has come to a conclusion. And I'm challenging that decision in my writ petition. Lordship, as far as the qualification to be an indigenous person is concerned, Lordship.
The issue with regard to indigenous person, and just because he took part, does not mean that he is stopped from challenging the issue of whether that person has the eligibility criteria to appear for the selection process. That I don't think so
Lordship, may I?
so the writ appeal should be allowed, but the writ petition we'll have to hear the government,
Yes, Lordship.
or we'll have to hear the.
Inquiry was conducted by the state
Lordship.
government, it's a necessary part.
I respectfully submit, Lordship, that unless, since I've been appointed,
No, no,
I'm still in service.
see.
My service has not been terminated yet, Lordship.
enough of that. We are, you see, the thing is that you have been selected.
Lordship,
He has challenged your selection on the ground that you did not have the eligibility criteria to even participate in the selection process. Now, the petitioner, the writ petitioner here, his case is that you could not participate. And because you did not have that indigenous inhabitant certification in terms of the 1977 notification. Correct. Now, the single judge has decided that issue by holding that since he has taken part in the selection process, he cannot turn around and challenge your thing. He's not challenging your result. Result may be a consequence, but he's challenging your very participation in the selection process. So on that ground, the
that is
single
one
judge-
aspect of the
the single
judgment, Lordship.
judge decision, we're not finding it to be correct. We don't find it to be correct. However, as the single judge has also directed that a verification should be made by the concerned authority and decision should be made. It has been made in the meantime, and you have put a challenge to that. So we are not setting aside your order or anything. We'll just say that the issue of whether you should continue will depend upon the decision to be made in your petition.
Lordship, as far as the read appeal is concerned, if your Lordship is inclined that,
Because you see, the issue is
Hmm.
with regard to whether you are an indigenous inhabitant or not. Otherwise, if this writ appeal, if we do not decide this writ appeal, your writ petition will always have the democratically sought of the single judge's order in his writ petition,
Lordship,
hanging over the decision to be made.
Lordship, I may be allowed to make a short submission in that regard, Lordship. My humble submission is that unless the read petition is determined, the read appeal cannot be determined at this stage, Lordship, because Lordship, firstly, Lordship, my contention is that Lordship is not inclined in
You see,
going into my favor in that contention, but
the single judge. What we can do is, we set aside the learned single judge's order. And we will say that let his writ petition, along with your writ petition, be heard to them.
That can be done. Lordship.
That's all.
Lordship,
Then everything is back to square one. Otherwise, if this writ appeal, unless the single judge's order is set aside, then how can the coordinate bench come to different findings with regard to his case?
Lordship, there are two aspects in the read appeal, Lordship. I have two contentions, Lordship.
He has one intention, he's got one contention.
Yes.
His contention is that you are not an indigenous inhabitant. Now, the learned single judge, while deciding the issue, said that he cannot make a challenge to the selection process because he had participated in the selection process without taking a decision with regard to whether you are an indigenous inhabitant, which directed that a verification should be made. So, we are not setting aside your order. of appointment. We are not saying that you are not an indigenous inhabitant. We're just setting aside the decision of the learned single judge, saying that just because he had participated in the selection process, he cannot put a challenge to whether you are an indigenous inhabitant or not. That is the wrong decision. That's all.
Lordship,
You can go to
that is the
Supreme Court,
settled
Mr.
position of law, Lordship.
Huh?
That is the settled position of law, Lordship.
Decision
Knowing
of
fully well that he
independent-
has participated,
You
Lordship.
see,
Lordship.
no decision has to be read in isolation. It has to be read as the Euclid's theorem case. So it depends upon the facts and circumstances of each case. When you are not, if you see when the issue of whether you are an indigenous inhabitant is settled, say here or wherever, then the next issue will be whether you could have participated. And the answer will be, if yes, you are an indigenous, then yes, then no problem. But if it's no, then you'll have to be terminated from that post.
Lordship.
So we are not going to decide whether you're indigenous or not as on it. We are just going to say that the decision of the learned single would be like a Damocles sword hanging over your repetition, the decision to be made in your repetition, which the learned single judge would have to abide by this order already passed by the learned single. That cannot be allowed. But that's a different issue altogether. Right? Now, heard Mr.
Lima Wapa.
Dema Wapa, learned counsel for the appellant. Also heard Mr.
DKJ, Lordship.
Huh?
DKJ.
DKZ, learned counsel for
Respondent number 4.
spur number. No, the spur number 4 in Achavit.
The writ appeal.
In writ appeal, Lordship.
Have to change this. Heard Mr. Lima Wapang, learned counsel for the appellant. And the writ petitioner in WPC number
WPC number 176 of 2019, Lordship.
176 of 2019. Pustav. Also heard Miss
Pichano,
Pichado,
Lordship, on
Le-
behalf of Tipapong.
learned counsel appearing on behalf of Mr. E.
The state.
Sivapong, for the state. Also heard Mr. So, learned counsel for the respondent number 4 in the writ appeal and the writ petitioner in
WPC 296.
WPC 296 of
2023.
2023.
The facts of the case is that advertisement dated 17/1/2018 had been issued for filling up the post of sweeper in the office of the additional deputy commissioner, Hugo Boto, Haring Pustak. The eligibility criteria required for participating in the selection process was that the candidate was required to be an indigenous inhabitant of Nagaland. Pustak. The respondent number 4 in the appeal had secured the highest marks in the selection process and was appointed to the said post of sweeper. Pustak. The grievance of the appellant was that she should have been appointed to the said post instead of the respondent number 4. In as much as the appellant had secured the second highest marks. Pustak. And for the reason that the respondent number 4 was not an indigenous inhabitant of Nagaland as provided in the OM dated page
46, Lordship.
in the notification number AR-8/8, no, 8/8/17 dated 28/4/1977. This is at page 46.
46, Lordship.
Pustav. The next paragraph, the appellant filed WPC 176/2009, praying that she should be appointed to the post of sweeper instead of the respondent number 4. During the proceeding of WPC, that decision by the authorities cancelling a indigenous inhabitant certificate was made when after the decision was made in his case.
During the pendency of the read petition, a decision has been passed by the ADC earlier. I have challenged that by filing a read petition, and in the common judgment and order, it was passed in my favor. That order has been cancelled, set aside.
Okay. During the proceeding of WPC 176 of 2019, the indigenous inhabitant certificate issued by the Office of the Additional Deputy Commissioner, Pogo to the respondent number 4 was cancelled by the order dated 10/12/2019. Being aggrieved by the cancellation of the indigenous inhabitant certificate dated 14/6/2013, the respondent number 4 made a challenge to the same by way of the present WPC 194 of 2020. Just a moment. Next paragraph. The learned single judge disposed of WPC 176 of 2019 and WPC 194 of 2020 by a common judgment in order dated 4/3/2020, by holding that as the appellant had taken part in the selection process for appointment to the post of sweeper, she could not turn around and make a challenge to the selection process. The learned single judge also held that as the cancellation of the petition indigenous inhabitant certificate by the additional commissioner Pugo was without any reasons, was made without any reasons, the same could not be upheld and accordingly set aside the order dated 10/12/2019 issued by the additional deputy commissioner Pugo. In the common judgment and order dated 4/3/2020, the single judge, the learned single judge, directed the additional deputy commissioner Pugo to make a fresh inquiry with regard to whether the respondent number 4 was an indigenous inhabitant of the state of Nagaland in terms of the notification dated 28/4/1977. Next paragraph. This is already said this. Next paragraph. Consequent to the impugned judgment of the learned single judge, the additional deputy commissioner issued notification dated 25/4/2023, wherein it held that the respondent number 4 was not an indigenous inhabitant of Nagaland. Accordingly, the indigenous inhabitant certificate dated 14/6/2013 issued to the respondent number 4 was again cancelled. Next paragraph. The respondent number 4 has now put a challenge to the notification dated 25/4/2020 issued by the additional deputy commissioner Pugo in WPC 296/2020. The learned single judge while order dated 30/11/2023 passed in WPC 296 of 2023 state the notification dated 25/4/2023. Next paragraph. This court, in its order dated 7/12/2023, had held that in view of the developments that had taken place with regard to the present case, it was of the view that the writ petition filed by the respondent number 4 would have to be disposed of along with the writ appeal to decide all issues pertaining to the present case. Next paragraph. However, on considering the submissions of the considering the submissions made by the counsel for the parties, we are of the view that unless a decision is taken with regard to the impugned judgment and order dated 4/3/2022, passed in WPC 176 of 2019 and WPC 194 of 2020. It would be difficult to take a fair and unbiased decision with regard to WPC 296 of 2023. So accordingly, we are of the view that the present writ appeal should be decided only to the extent that should be decided only with regard to whether the learned single judge was correct in holding that the appellant could not make a challenge to the selection process only because the appellant had participated in the same. Next. The notification dated, that is page 46. Okay. The notification dated 28/4/1977 provides the criteria to be considered while deciding whether a person qualifies to be an indigenous inhabitant in the state of Nagaland. It requires the person indigenous for the indigenous inhabitant of the state of Nagaland for the purpose of employment. First, it requires that the person should have settled permanently in Nagaland prior to 1/12/1963. And the criteria to be followed for determining whether a person is a permanent settlement in the state of Nagaland prior to 1/12/1963. The following have to be considered. This page 46, you take it down. The following have to be considered: 1, 2, 3. 1, 2, 3 at page 46. Then you write the entire notification, the contents of the The entire contents of the notification dated 28/4/1977 is reproduced herein below as follows. Page 46. Next. Where is the advertisement for that selection process?
Should be coming from the page number 32. The present rate petition is concerned with serial number 14.
Page 32.
Yeah, yes, Lordship.
The advertisement dated 17/1/2018, for which the appellant and the respondent number 4 whatever I said, the advertisement dated 17/1/2018 for filling up the post of sweeper, in which the appellant and the respondent number 4 had participated, required that the person should be an indigenous inhabitant of the district. Which would have to be covered in terms of the notification. No, comma, which would thus have to be covered in terms of the notification dated 28/4/1977. Full stop. When the issue was with regard to whether the respondent number 4 was an indigenous inhabitant of the state of Nagaland for the purpose of employment, comma, the learned single judge, comma, in our view, had incorrectly considered another aspect, that is with regard to her non-selection in the selection process without elaborating on the same. The appellant has not made any challenge to the selection process or to the selection process. It had only made a challenge to the eligibility criteria of the respondent number 4 to have participated in the selection process. As such, the decisions of the learned single judge, where is that order?
Page number page 85, Lordship. Lordship, the decision is in June decision is para 12 to 15 in the main judgment.
The decisions relied upon by the learned single judge while deciding WPC number
176 of 2009.
176, no, while deciding the appellant's writ petition would go to show that those decisions pertain to variations in the contents of the advertisement and the rules and the process that had been undertaken by the authorities in the selection process. The decisions relied upon by the learned single judge, that is Madras Institute of Development Studies and another versus K. Siva Subramanian and others, reported in 2016, 1 SEC 454, page 95 and 96, Manish Kumar Shahi versus State of Bihar. No, not that. And Ashok Kumar and other versus State of Bihar and others, 2017 4 SSC 357, in our view, was not applicable to the issue to be decided in with regard to the grievance raised by the appellant. As such, we are we are of the view that the impugned judgment and order insofar as it relates to the challenge made by the appellant to the selection of the respondent number 4 on the ground of the respondent number 4 not being an indigenous inhabitant of the state of Nagaland for employment is not sustainable. The impugned judgment, as insofar as it relates to the issue quoted above, stated above, is hereby set aside. Next paragraph. The above being said, the impugned judgment and order dated 4/3/2022 passed by the learned single judge in WPC 176 of 2019 and 194 of 2020, insofar as it has directed the additional DC Pocoboto to conduct a inquiry and take a decision as to whether the appellant, the respondent number 4 was a indigenous inhabitant of the state of Nagaland for the purpose of employment is not being interfered with. Full stop. Full stop. Next paragraph. As the learned and as the additional DC Pocoboto has acted upon the direction of the learned single judge in terms of the impugned judgment and order and decided that the respondent number 4 is not an indigenous inhabitant of Nagaland, which has been put to challenge in WPC 296 of 2023. We are of the view that the said issue should be decided on a subsequent date as the to be a subsequent date along with WPC number 176 of 2019, which is restored due to the setting aside of the impugned judgment of the learned single judge dated so and so,
4/3/2022.
4
4/3/2022.
2022, to the extent indicated above. The writ petitions accordingly, the writ appeal is accordingly disposed of. Only the writ appeal. Anything else? Have we missed out anything?
Worship, the writ petition, the two writ petition may be listed next week for disposal. Early disposal is required in this case.
Yes.
Next week.
Next week, Lordship.
Okay, right. List WPC 176 of 2020
Along with 296.
along with WPC 296 of 2020.
23.
5.
23, 23.
23 in the next week. That way, everything is back to square one.
Worship.
Lordship.
Obliged, Lordship.
Yes. Let's take with
Lordship, I beg to mention item number 21 hearing. Matter may be released on the next month, 4th. Item number 21 is all matters.
Okay, okay.
No objection, Your Honor.
I have taken the consent of the senior counsel.
Okay, right.
MT
On the
himself.
prayer for adjournment made on behalf of, made by the respondents, list the matter on 4th. Yes, sir?
Please, Your Lordship. Your Lordship, may I be pleased to mention item 12. Your Lordship, on 18th November, we made a mention that this matter has to be listed along with 170 of 2025 after 3 weeks. So Your Lordship, accordingly, let this matter come along with 170 of 2025.
Lordship, no objection.
But you're asking for creation of a post.
No, Lordship. For regularization of,
Regularization has to be against the post,
yes, Lord.
and there's no post.
Yes.
How would you regularize a person against a non-existent post unless it is created? And creation requires money. If the state says it has no money, then where's the question of creation of a post?
Meantime, let the government file the affidavit, Lordship.
There are Supreme Court judgments which says that you cannot force the government, the courts cannot direct the government to create posts. Anyway, you file that affidavit.
Yes, Your Lordship.
Ms. Levika is granted how much time?
3 weeks, Your Lordship.
How much?
3 weeks, Your Lordship.
3 weeks to file affidavit opposition.
Your Lordship, let it take along with 170.
Along with WPC number, this matter along with WPC number 170
170
of
of
2025.
Much.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item 234, the analogous. I'm yet to receive instruction on item 4, which was just filed last month, Your Lordship. So some time may be given. These are related matters, Your Lordship.
What you received what?
And for the state respondents,
You received instructions
I'm yet to receive for item 4.
for item 4.
Yes, it
But
was
the
filed
item
last
4
month.
has been
Yes.
recently filed by the petitioner. Because Lordship, there was a direction from this honorable court directing the deputy commissioner to verify the land, whether it's a common land or it's an individual land. So on the basis of the court direction, a verification was conducted by the deputy commissioner. The deputy commissioner submitted this report saying that this is a common property donated by different individuals and clans
Okay.
for setting up the school in Chetima village. Now the petitioner has gone before this court challenging the order of the deputy commissioner, the verification report. Now, Lordship, these are purely disputed question of facts.
That's what I think we should go to civil court.
They should go to civil court. I have raised my objection on that line, Lordship. And the
This
president,
is a disputed question of fact. Disputed question of fact cannot be decided in the High Court.
whether the
You need evidence, Mr. Counsel.
Yes, Lordship, pardon, the report itself, Your Lordship, it's very confusing. Why? Because they have stated that the land which was given to the school education was.
Mr. Counsel, that is why you need evidence. That's why you're going to cross-examine you go to a civil court. Don't go to the deputy commissioner, go to a civil court.
yes,
You withdraw these matters will give you liberty to go to civil court. That's the only way out. It will not be decided in a high court.
whether the court
Whether
can
it is
decide.
an ancestral land or what, of those persons.
Exactly, Your Lordship.
Lordship, in that case, Your Lordship, then it may be less after a week, Lordship.
Why?
I'll take a proper instruction from the petitioners, Lordship.
Mr.
Subramati.
Supamati, learned counsel for the petitioners, submits that he would like to obtain instructions as to whether the petitioners would want to withdraw this case and approach the civil court. Stop. The stand of the respondents, on the other hand, is that as they are disputed questions of fact, the evidence would be required to be adduced, for which the petitioners should approach the civil court. List the matter in the next week.
Lordship.
Obliged,
Obliged,
Lordship.
Lordship.
Please, Your Lordship, I beg to mention item number 7. Your Lordship, I'm appearing on behalf of my senior, Nityo Koza, counsel for the private respondent 6. She's not available for appearance today due to some unavoidable circumstances, so
Item 7.
yes,
Okay.
Your Lordship. The matter may be listed next week.
For the petitioner.
Any problem?
No.
On the prayer for adjournment made by Ms. Nitya Koza, on behalf of Mr. Nitya Koza, learned counsel for the respondent number 6, list the matter in the next week.
Much obliged.
Maybe it's your lordship, I beg to mention item 11.
Yes.
Your 11. Lordship, we have received the affidavit, so some time may be given to go through, and if necessary, we will file our reply.
Madam, we can dispose it of this matter as per the page, as per that page 3. Only one thing you have said, that the petitioner is in the seniority list. That seniority list would not cannot be applied. This is a case of landowner.
Yes.
So that will be stand on a different footing.
Your Lordship.
Correct?
The seniority is as per the.
That is for contingency workers.
Yes,
But this person may be appointed as a contingent worker,
yes,
but
on land ownership.
is on land ownership
Yes.
basis. So that will be on a different footing.
Yes,
You cannot apply that seniority.
Yes.
We'll dispose it of. But they have agreed, madam. You know, have you read the affidavit, counter affidavit? What has been stated there? Read page 3 of the counter affidavit from the top.
That since the relief sought by the petitioner on WPC number 141 of 2028 or 2008 was granted, this honorable court by order dated 15/2/2010 dispose of the said writ petition with direction that since the petitioner has already been appointed as peon cum chokidar on contingency basis, the relief sought by the petitioner has already been granted, and therefore this writ petition stand closed. However, since the appointment of the petitioner is only on contingency basis, the department should consider his appointment on regular basis on expiry of the terms.
Continue. The next is the important part.
That the answering deponent humbly submit that in compliance with the order and direction of this Honorable High Court, the office of the answering deponent has given earnest consideration to regularize the petitioner. However, due to absence of regular and sanctioned vacancy posts in the school in which the petitioner is serving, the case of the petitioner could not be considered for regularization. However, the answering deponent respectfully submit that the department shall consider the case of the petitioner for regularization as when a clear vacant sanction post arise in the said school in which the petitioner is presently serving.
As soon as a vacancy arises, they're going to consider you. What more do you want? If you need to file a reply, that we have to pass the same order. We say that as soon as a vacancy arises, consider you. That's all. So we close the matter, madam. Okay. I mean, I'm not forcing you to do anything. But that your averment in para 5 that cannot be
Yes.
sustained. Huh?
That is for granting of scale of pay, Your Lordship, as per the.
Naturally, once you regularize, they have to be given scale of pay.
Yes, that is.
Once you regularize. But so right now there's no vacancy. So there's no vacant regular sanction post as on date. As soon as there is a regular vacant sanction post, they are going to consider you. Okay. Heard Mr.
M. Longkumar.
Oh, sorry. Heard Miss Rebecca.
Yes, Your Lordship.
Heard Miss Rebecca, learned counsel for the petitioner. Also heard Mr. N. Longkumar.
M.
Longkumar.
Yes, Your Lordship.
Counsel for
The state respondent.
state respondents. The petitioner seeks a direction to the respondent authorities to regularize his service in compliance with the order dated 15/2/2010, passed in WPC 141K of 2008. The next paragraph, the relevant portion of the order dated 15/2/2010 passed in WPC 141K of 2008 states as follows. Huh? It is there in that, yes, in the affidavit in opposition at page 3. The bold version, bold version, okay? What about this um, pay? You have to give the minimum pay scale.
Yes, that is, this para 5 relates to that, Your Lordship. That his name has been sent for a scale of pay. And he's standing at serial number 215 as of now.
There's not a question of seniority, scale of pay.
That this is as per the OM, Your Lordship.
Okay, as per the way.
Yes, as per the OM, Your Lordship.
The petitioner's further prayer. The petitioner, by way of this writ petition, also seeks a direction to be issued to the respondent authorities to grant scale of pay as is being paid to regular employees. Full stop. Next paragraph. The respondent respondent numbers 1 to 3 in para 4 and 5 of their affidavit have stated as follows. Just take it down, okay? Next para. A perusal of para 4 of the affidavit of the respondents number 1 to 3 shows that the case of the petitioner for regularization shall be considered as and when a clear vacant sanction post arises in government middle school bracket GMS bracket close PURRUR. How do you pronounce this?
Parur. I think,
Parur.
Yes, sir.
Okay. Next paragraph. Further, the the prayer of the petitioner for grant of pay scale, as is being paid to regular employees, has been answered in para 5 of the affidavit of the respondents number 1 to 3. To the effect that the scale of pay of the petition, the scale of pay would be granted to the petitioner as per the standing policy of the state, which is in terms of P and AR Office Memorandum dated 5/3/2025 and Finance Department Office Memorandum dated 5/5/2025. Full stop. Further, it has been stated that the concerned department, wide letter dated 6/8/2025, has duly submitted a comprehensive roster of contingency and casual employees to the government for conversion for conversion from fixed pay to scale of pay to scale pay to scale pay. Next paragraph. In view of the above statements made by the state government in their affidavit, nothing is required to be adjudicated any longer. Accordingly, the respondents shall consider the petitioner for regularization as and when a clear vacant sanction post arises in government middle school Parur.
Parur, yes.
Parur.
Yes, sir.
First of also, the state government shall take a decision on the question of payment of scale of pay of the petitioner within a period of
1 month.
6 months, it will take some time, Your Lordship. Six
Lordship.
months would be more appropriate, Your Lordship.
Okay.
okay. Okay, within a period of why 6 months, half a year?
So many procedures to follow, Your Lordship, but just to ascertain that we consider.
Okay, since he said yes, within a period of 6 months from the date of receipt of a copy of this order, the writ petition is accordingly disposed.
Oblige, Your Lordship.
Anyway, you are going to ask for time to file your reply, so it's okay. And that means it would have ended up in January, middle of January. So 3 months would have gone there itself.
Oblige, Your Lordship.
May it please, my lord. My lord, I'm mentioning on behalf of my senior Asia, my
Oh.
lord. I beg to mention item number 1, my lord.
1,
Yes, my lord.
why are we going backwards? Yes, what about 1?
My lord, I pray
I
that.
thought this is mentioning. Oh, we're still in the mentioning stage, okay.
I pray that, my lord, may this matter be come out after 2 weeks, my lord.
So, the paper book has been given?
Yes, Lordship.
Yes, my lord.
So all
It's
of you, so we can receive for hearing.
Lordship, yes.
Yes, my lord.
When do you want for hearing?
My lord, then after vacation, my lord.
POXO 376 POXO, how does it matter? How does it affect you? Doesn't affect, it affects him only.
Yes.
Right, the counsel for the appellant prays for adjournment on behalf of Mr. Azo, the leading counsel. The counsel for the respondents submit that they have got no objection to the same. As paper book has been furnished to all the counsels, list the matter for hearing.
My lord, I have a small prayer, my lord. After the name of my senior Asia, may Amika's career may be reflected, my lord. He is also appointed by the registry, my lord.
At the time of hearing, you can do that. Okay. List the matter for hearing in the month of January,
Lordship.
2026.
Lordship.
Much obliged, my lord.
Oblige, Lord.
May please, Lordship, I beg to mention item 5 and 6. On behalf of Bijoy Deb, the leading counsel for the petitioner.
No. How can we do that? Where is he?
The-
Where is he?
He's in Shillong.
Huh?
He's in Shillong. He's based in Shillong.
He is in Shillong.
Yes, my lord.
There is no case here.
My lord, the pleadings are complete. The
Pleadings are complete, but you have
the
got
picture
no
me-
case.
today he has some personal difficulty to appear. So kindly list after 1
Tell
week.
him to appear virtually. Tell him to appear virtually. We'll allow virtual appearance.
My lord, today he's not in the condition.
Okay,
to
tomorrow
appear.
virtual appearance. Tell him to appear virtually tomorrow. Okay. Mr. What is your name?
I am Pakirin Chau, my lord.
Mr. Pakin Rinchapbo, learned counsel for the petitioner, prays for adjournment. Accordingly, release this matter tomorrow. Mr. Pakin Rinchapbo shall also inform his senior counsel for his leading counsel that the leading counsel can appear virtually tomorrow.
Hello, Lord.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 8.
8. Yes.
I'm mentioning on behalf of my senior, Younger, as he's having some personal difficulties. If 3 weeks may be granted to file rejoinder affidavit.
There's no question of rejoinder.
to the affidavit and opposition filed by respondent number 2 and 3.
You're claiming pay from 2020 till 25. They have said that they have paid you from 22. So this is a disputed question of fact. Where is Mr. Senthi Younger?
He's having some personal difficulties.
Where?
Yes.
In Kohima?
No, out of station.
Let him appear tomorrow virtually. Yes, what is your case?
I'm only for the state respondent number 1. And we don't have any, we won't be filing any affidavit.
Huh?
The main concerned parties are respondent 2 and 3, Your Lordship.
Who is appearing for 2 and 3?
One is Soka. I
Huh?
believe he's absent today, Your Lordship.
Okay, right. On the prayer for adjournment made on behalf of Mr. Senthi Younger, I'll list the matter on when do you want?
Tomorrow.
Mm.
3 weeks.
Oh, no. We'll save you tomorrow, but he can come tomorrow. Are you sure?
Back next week, Your Lordship.
Okay, next week.
Yes.
The matter in the next week. There appears to be disputed questions of fact involved in the present case. That's all.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item 9 and 10. Lordship, if this matter may be listed after 2 weeks in the presence of my seniors.
Where is the senior?
He's out of station, Your Lordship.
No, madam, tell him to appear. You see, we cannot adjourn all matters like this. We come prepared. We read the file. We should. There is a notification issued by the High Court that if you're going to ask for adjournment, ask for it 1 day earlier at least by way of a written application. There's a form. I think you're wasting our time. If I hadn't read it, it's okay, but I've read it. And there's no case. If you had a case, okay, I would have adjourned, but you've got no case. You're retired in 21. You're praying for regularization now in 25. There's no case.
If I may, Lordship, supplementing to my writ petition, I would like to put up a similar situated case.
Please.
Lordship, in WPC 104 of 2024, Court's order dated 21/02/2023. The case of the similar situated person has been considered. Here, the petitioner was released from service on 31/2/2022, and after retirement, the petitioner submitted the representation on 19/02/2020. And the petitioner in this writ petition, his service was regularized in 15/9/2024 after 4 years of retirement, Lordship. All the work charge employees who are enjoying scale of pay, they are regularized even after retirement as per the office memorandum.
So in your case, you are covered by the office memorandum.
Yes, Lordship.
But then why have you filed your representation only after you retired?
Lordship, I was hoping that the state respondent would consider my case. However, I was released on retirement.
Now, what are you expecting if you are regularized?
Lordship, to grant pensionary benefits and also to grant errors.
Huh?
to direct the state respondent to immediately consider for regularization and also grant all pensionary benefits entitled to the petitioner and direct the state respondent to pay all arrears to the petitioner on
All
completion of
arrears?
30 years. 30 years.
All areas.
Yes, Lordship.
Now, how can you turn the clock back? Another thing, madam, is, you see, there is one thing. Whether the new pension scheme is applicable in Nagaland or not. Yes, is it applicable? Government, Ms. Chang?
NPS, yes, Lordship.
NPS, applicable, no?
Yes, Lordship.
So depending upon when you are regularized, you would be entitled to NPS, National Pension, New Pension Scheme.
Yes, Lordship.
And under the new pension scheme, there has to be a contribution made to the pension from you and from the government. Now, where is the contribution going to be made for past services? You have slept over your rights, madam. That's the problem. And then there's a division bench judgment of yours, of this court, on 8/6/23 in WA 27 of 22. Slightly different facts, but one aspect is there. It says here, it also has to be noted herein that the respondent had never made a prayer for regularization of his service prior to his retirement. Same here, you did not make.
Yes, Lordship.
The representation was submitted only after he retired from service, and that too only for the purpose of receiving pension. And the division bench did not allow. And here you are claiming arrears. Arrears for what? I don't know, because you have not been regularized. Yes, madam, anything to say?
I leave it to you, Lordship.
No, you see, madam, one thing, there's no point keeping a case pending where I don't think you'll have got a case. If you have got a case, it's all right. But if you don't have a case, no point keeping it pending, giving false hope to the client. There are decisions, and there are also the fact that, you see, you started work in 2005. Correct? 2005. You were appointed as what in 2005?
Work Judge Kalasi. Work Judge
Work Judge
Kalasi.
Kalasi. And then you promoted.
Lordship, my apologies. I was appointed as Work Judge Leper and I was upgraded to Work Judge Kalasi.
When?
2020.
2020.
Yes, Lordship.
And you retired in 2022.
21.
21.
Yes, Lordship.
And you filed a writ petition in 2025.
Yes, Lordship.
Now, can we turn the clock back? I could understand if you had made a representation during your service period. But you have not made a representation during your service period. You made a representation after you retired.
Lordship, to supplement more to it, if I would also like to.
Yes, yes,
put up-
please, yes, please. You show me something where this court can pass an order in your favor, no problem.
Lordship, here the petitioner during his service time, he has not approached the authority for consideration but submitted representation after his retirement.
So, what is the court said?
The court has given.
Let us see the case. Work charge carpenter. in the scale of pay, he's given scale of pay,
Yes, Lordship.
you're given fixed pay. No, madam, out here, it is for those who will complete 30 years of continuous service after 1/1/25. You have not completed uh, 25 years of service also.
Lordship, I have completed 30 years of service.
30 years of service?
Yes,
When,
Lordship.
2005 you were appointed, no?
I was appointed on 1986, Lordship.
86.
Yes, Lordship.
It's slightly different here, madam. Yes, you are given you are given a regular pay scale. Now, from what date? Look, you are claiming pensionary benefit.
Yes, Lordship.
Now, from what date should you have been regularized, according to you? Cannot be from the date you are appointed. And there's a division bench judgment. These are single bench judgments. What we can do is we can ask the state government to consider your representation. We'll take a decision. We won't mention the division bench judgments.
Lordship, if this matter may be fixed in the presence of my senior.
Tell him to come tomorrow.
Okay. Yes,
Or
Lordship.
if he cannot come tomorrow, tell him to come. Tell him to appear virtually. You see, madam, I've heard you also. So tell him. Others, we'll record your name and we'll dispose it of. Tell him that he must appear virtually if he cannot come.
Lordship, tomorrow.
Okay, right. Adjournment prayer has been made on behalf of the petitioner's counsel. Mr. By Miss?
Muthoy.
Huh?
Muthoy.
Muthoy, on the ground that her senior is not present. Accordingly, leave this matter tomorrow, by which date the petitioner's counsel should appear either personally or virtually.
Lordship, similar prayer for item 10.
Okay, similar order.
Vice Chair.
From the supplementary cost list for motion, item number 25.
Supplementary for this. Oh, I didn't know this.
Please, my lord. This is a case
Oh,
of.
I did not see this petition. Okay, just a minute. What is
Please.
Where is the impugned?
Lord, impugned order is at page 103, my lord, and Excel P1, my lord. But without so-called notice, my lord, punishment order is passed, my lord. Even punishment order is not served to me as on date, my lord. It was circulated on WhatsApp, my lord, we came to know.
So it has been served to you by WhatsApp. Service of notice by WhatsApp is also accepted.
No, not by same, my lord, in the group, my lord, of the consultant, my lord. Not by the respondent, my lord. So-called notice has also not been given, my lord. My lords have already delivered one judgment last year, my lord, where Lord so-called was not given. I argued before my lord, and this judgment was passed, my lord, relying on the judgment of Eurasian equipment.
That is with regard to debarment.
This is also same, my lord, non-performer, my lord, punishment is given, I cannot participate.
No, we'll issue notice first.
Lord, I'm praying for interim because there are, I'm 3 grounds, my lord.
No, let them, you first will issue notice, you take this thing.
My lord,
You
in the
take,
meantime, my lord, may protect me, because my bids are not being considered, my lord.
Maybe.
Maybe an XL P2, my lord. They have
When-
been non-responsive because of this order, my lord.
We'll give a short date. You give Dusty notice, Dusty service. We'll list it in a week's time. Next week we'll list it.
My lord, may hear me 2 minutes on the interim, my lord, if I'm able to convince, my lord.
Not this way.
Lord, they have. exceeded the judicial-
Within, heavens will not fall within a week.
Lord, my bids are not considered. I am not able to participate also. Not.
What bids? Where? Which bids?
Please see annexure 2, my lord.
Page?
Page 111, my lord. This was the bid submitted in April, my lord. And now they have declared me non-responsive because of this order. It starts from page 111, my lord. Kindly come to page 112, my lord. Serial number 15. Page 112. Serial number 15, my lord. Petition.
How do we know that this non-responsiveness is due to this
It's
order?
written here, my lord, column 2, my lord. The bidder Messrs. AI Con Engineering is debarred by NHIDCL wide letter number so and so and dated 11/11/2025. This is the impugned order, my lord, punishment order. Because of this order, they are not considering any of my bids, my lord. There are 70 bids in the pipeline, my lord, and there are 100 bids which I have to submit next 2 months, my lord. So it's a complete civil death of the company, my lord. I am not able to participate. My bids are not considered.
We'll list it on Monday. You take steps.
My lord, I come from.
No, you might come from Timbuktu. How does it matter? We have to give some notice to
Not
them.
even the punishment order, maximum punishment of non-performance is for 1 year, my lord. Can you see that circular?
No, that is what you see. Today is what? Today is Thursday.
Please, my lord.
Today is Thursday, Friday, Saturday, Sunday. You serve notice by Saturday. You file it by Monday, your affidavit. We take it up on Tuesday. On Tuesday, we will record that your prayer for interim will be taken up.
Then my lord, have it on Wednesday because Monday.
Wednesday is the DB day out.
Not then Thursday, my lord, because Monday I am in Allahabad High Court, my lord, so I cannot reach from here.
You see, there is nothing that we do not believe what you have said. The only thing is that some note, when we are issuing a stay order.
But
against
similar order has been passed last week.
No.
Same case, my lord. There also, so-called notice was also not given, my lord.
No, we'll have to see. We have to hear them. Otherwise, sometimes we have to hear them.
But kindly.
Some notice has to be given.
My lord, I was not the lead partner, my lord. They were corresponding with the lead partner. I was the silent partner, my lord. They were not, even the order is not served. Please see the, my lord. It was sent through email only to the lead partner, my lord. Not subject to outcome, let my bit.
Where's your representation?
Representation we have not given, my lord.
We have come directly here.
But 11th order was passed, 12 we got.
How does it matter? You have to, it's your duty to give a representation to them prior to coming to this court. Taking up the issue that you have not been given a copy, you have not been heard, you have not been issued any show cause, nothing. It is your duty. You know the law. Heard Mr. Rajiv R. Raj, learned counsel for the petitioner, who submits that the petitioner company has been declared a non-performer for a period of 3 years.
2 years.
2 years. Or till rectification of deficiency, whichever is later. As per the action prescribed for the firm under clause 3 of the ministry's circular dated 7/10/2021, thereby debarring the petitioner from participating in any bid pertaining to the National Highways projects with MORT, M-O-R-T and H, M-O-R-T and H, or any other executing agency. The petitioner's counsel submits. No, wide letter dated 11/11/2025, issued by the NHIDC. The petitioner's counsel submits that no notice was issued to the petitioner prior to debarring him from participating in any project. And neither was the impugned letter dated 11/11/2025 furnished to the petitioner. Issue notice returnable in a week.
My lord, may I just show the circular for a minute, my lord, where the maximum punishment is 1 year, my lord. They have given 2 years, my lord. Prima facie, my lord, I am trying to make out my case for the state. Kindly come to page, my lord, 180, my lord. Maximum punishment can be only for 1 year.
That will take it up. That issue will take it up. Okay, but that issue can be taken up on the next day.
My lord, prima facie, I am trying to establish.
Prima facie, you have not.
It is their circular, my lord. Their circular says that non-performer maximum should be 1 year.
Correct. So this is
They have given me 2
this
years.
order is of 11/11/25.
They have given me for 2 years, my lord. They have
That we will set aside. That will be set aside. If it's not as per the circular, that will be set aside. That's not the issue.
I'm only trying to make out my case for
I
that.
agree. We heard you. Just right. Okay, just right. The petitioner's counsel submits that in terms of the ministry circular dated to 7/10/2025, debarment can only be
At the
enforced for a period of 1 year.
But as per the allegation, it can be only 6 months.
In the present case, the petitioner has been debarred for 2 years. First, issue notice returnable in a week. Petitioner takes steps for service of notice upon the respondents by speed post during the course of the day. Next para. In addition to the above, he's here. Here for? Right, Mr. Yangavati. You are taking adjournment today. Did you take adjournment today? No. Okay. Anyway. What have I said? In addition to the above, the petitioner is also allowed to serve notice upon the respondent number 1 by way of dusty service. Just a minute. By way of dusty service. This is Kohima. They live in Kohima. You could have served them.
Lord,
You come.
my friend tried to serve them, they refused, my lord, because there are.
Where is that? Where is that government?
He tried to serve, my lord. There are 3 standing council, my lord, so.
Mr. Council, you serve it upon this person now. What have I said? By way of dusty service, within 4 days, within 2 days, and file affidavit of service thereafter. The interim prayer shall be decided on the next date, in as much as no representation with regard to the impugned letter dated 11/11/2025 has been filed by the petitioner till date, prior to approaching this court. This is the matter on 27. Acha, Mr. Yangarwati accepts notice on behalf of respondent number 2.
For admission, item number 13.
Maybe, His Lordship, Your Lordship, my senior is on legs in court too.
No, we'll wait.
Yes, Your Lordship.
For admission, item number 14.
Lordship, I received information from the legal counsel for the petitioner that he is on bereavement today, Your Lordship. Estemjen.
Yes, so.
My lord, I'm yet to receive instructions. This pertains to.
I know, quarrying.
Yes.
Now, the land on which he is doing the quarrying.
Yes.
Is it his land? Is it the petitioner's
He's
land?
doing the quarrying of stone nearby the.
Nearby the tower, electrical
Yes,
tower.
yes.
No, my question is he doing the quarry? Is he doing the quarry
Yes, my lord.
on his own land? Or
Yes, my lord.
It's on his own land.
It is stated.
That is his case. Then the tower is on his own land, on the petitioner's land, or is outside the petitioner's land?
This. If I may be allowed to read.
Yes.
Annexure 6, my lord.
Yes.
Running page 66.
Yes.
Of the writ petition.
Yes.
May I read, my lord?
Yes, please.
Restraining order dated 18 May 2023. 1. Whereas a complaint has been received from the office of the Park Creek Mogokchung White Letter such and such dated 2nd May 2023 that a certain landowner is carrying out stone quarrying activity near tower location 152 of 2020 to 220 kV double circuit main Merani Mogokchung transmission line in CDC area. As a result of which, the tower has become critical and prone to collapse. 2. Whereas the matter has been verified by the Extra Assistant Commissioner Ong Bangkong, and as per the report number such and such, dated Mogokchung 11 May 2023, the same concern has been found to be genuine and that further stone quarrying activity at the site will affect the stability and safety of the tower. 3. Whereas power/electricity is a public utility which is essential for economic and development, social development, and therefore ought to be protected for the larger interest of the public. 4. Therefore, in view of the criticality of the tower and considering its importance as stated above, the landowner concerned is hereby directed to refrain from carrying out stone quarrying activity near the said tower location till further direction in this regard. Failure to comply with this order shall attract appropriate actions as per the relevant sections of law.
No, that is all right.
Yes,
That is all right.
The main respondent here is from respondent number 6 onward.
I know.
My lord, I represent respondent number 6 and 7, my lord.
Yes.
Power Grid Corporation of India Limited.
Yes.
My lord, we have on the last date itself, we had only entered appearance for the first time, my lord. We have seeked time for filing an affidavit, detailed affidavit, to bring on record all the aspects because this querying activity was not there, my lord, as per my limited instruction today, when the transmission line was erected. It has subsequently taken place and which is now affecting the safety of the whole transmission system, my lord. As per the Electricity Act, there are certain safety norms and guidelines. So, my lord, give me 2 weeks time, my lord, to file an affidavit. Matter can be taken up for consideration.
You see, right now, the issue of the stay order, that cannot be changed. Because this is a public importance.
Yes,
it's an essential requirement for everybody now.
Yes, ma'am.
But the fact remains as to who had given him a quarrying permit, first of all. Whether the quarrying permit had been given by the state government. That has to be seen. Now, and then secondly, when was the power grid will also have to show.
My lord.
When was your tower constructed?
My lord, this transmission line, my lord, is over a decade old, my lord. More than 10, 11 years.
So it was done on whose land? Was it done on the petitioner's land?
My lord, once I file a detailed affidavit, my lord, we have asked for the records to come from the site.
No, so the reason we are putting this question to you,
my lord,
that you know what to put in your affidavit. You might be missing out on these issues.
My
It will
lord.
have a bearing on the disposal of the case. So
My
whether the tower has been built on the petitioner's land or some other people's land, whether compensation has been paid, or whether it has been done with the donation made by somebody, no, or whether for whatever reason. And then, so that is one. And then for you, will have to decide, government will have to decide, state government, as to whether you had given the permit to the petitioner to start quarrying.
No.
Here
I
it's
received
given by
instructions,
you. And then you'll also have to file an affidavit as to whether, a petitioner also, as to whether the land on which the tower is standing is on whose land, whether it is in your land or not. And one thing is very clear: he cannot endanger the tower. Tell that to the petitioner. He cannot endanger the tower. Just for one man, the entire, 1,000 people cannot suffer. The right of one man would have to give way to the rights of 1,000 people.
That is how, my lord, we have issued a restraining order.
So anyway.
My lord, this transmission line is bringing in a very huge amount of electricity into the state of Nagaland. Its share, my lord, from Palatana project in Tripura.
No, I was thinking of somehow disposing this matter, but since the petitioners' council is under bereavement,
my lord,
because the issue of the tower being, being damaged is just because of somebody quarrying to make money,
my lord,
is out of the question.
My lord, also, my lord, if any quarrying permit has to be given, my lord, the safety of the surrounding areas is a primary inspectional check.
Correct, has to be considered. So
My lord.
even for, you see, in states, like even in the state of Mizoram,
My lord.
if somebody has a house near the main road, he starts digging, the entire hill falls, and the 5, 6 houses also start get damaged. That cannot be allowed.
My lord.
So these things cannot be allowed. You tell the petitioner also. There's no question of interfering with the stay order.
No.
Mr.
Metavero on behalf of S.
You're not here.
I'm not there, Your Lordship.
Mr. Just say adjournment prayer has been made on behalf of Mr. S. Temjen, learned counsel for the petitioner, on the ground that he is under bereavement. Full stop. Mr.
LT Sanktam.
L. Sanktam,
LT Sanktam.
additional AG, appeals for respondents number 1 to 5.
1 to 5.
While Mr.
N. Khera, my lord.
N. Khera,
My lord.
for the respondents number 6 and 7. The respondents shall file their affidavits within 2 weeks. Full stop. On considering, is there any prayer? On considering the prayer for an interim order, for a restraining order, this court is not inclined to pass any restraining order against the respondents at this stage. This is the matter. On when? This is the matter after 2 weeks.
Obligement.
Highly obliged, my lord.
For orders, item number 15.
Yes, what has happened? Notice.
Lordship, on the last occasion, Lordship, I have contacted the IO, Lordship. However, Lordship, from the IO, it appears that the respondent number 2 has already changed the residence, Lordship.
So he does not
And-
know.
Yes, Lordship.
Actually,
we are
it's,
finding difficult-
actually, it's not from the IO that, you see, the notice has to be given by the concerned OC.
Lordship, from the concerned OC,
OC.
it was, the matter was referred to the IO to serve the copy to the notice to the respondent number 2, Lordship.
Where is the report in writing?
Lordship, I may allow a week's time, Lordship. In the meantime, we will file the report, Lordship. By way
Well,
of affidavit.
report, it's a short report.
Lordship, by way of affidavit, Lordship.
No need. You just,
Lordship.
the report should go to the PP,
Lordship.
signed by the OC or the IO, whoever.
Lordship.
If it's from the IO should write that he has been directed by the OC of the so-and-so police station to serve the note or serve the copy of the appeal or the revision petition to the respondent number 2. However, on going to the residence of the respondent number 2, it is found that they have shifted their residence and they do not know the whereabouts, or they know the whereabouts or whatever. If they know the whereabouts, the address should be given. If not, if they know the whereabouts, then the concerned, then he can go and deliver that. Otherwise, he'll have to say that he does not know the whereabouts. And signed by the concerned IO or the OC, it's enough.
Lordship, it seems they have shifted to their native place.
Natively.
Lordship.
Then let the OC of the police station which covers that native place
Lordship.
make a report to this OC and this or make a report to you directly. Enough.
Lordship will do
Okay,
that.
that's enough.
Lordship.
Whether he's served or not,
Lordship.
just let him serve it. Correct. Mr.
Vijmon.
Vizimomi learned APP.
Lordship.
Learned APP submits that the OC of the concerned police station had entrusted the service of notice of the appeal to the IO.
Lordship.
However, the IO has apparently communicated with the OC of the concerned police station, stating that the respondent number 2 has changed his residence. Full stop. The additional PP submits that he will communicate with the concerned IO
Lordship.
and if the whereabouts of the respondent number 2 is known, the notice will be served upon the respondent number 2 thereafter. He submits that a report to this effect would be made by the concerned IO by the next date.
Lordship.
List the matter on. How much time do you need?
A week's time, Lord.
Huh? A week's time. List the matter on 28.
Lordship.
This is a small thing.
Lord.
Just a report, no affidavit.
Lord. Obliged.
For orders, item number 16.
Yes.
Here I'm seeking appointment on the
Landowner basis.
as well as I'm challenging the appointment of
Your uncle's land,
lordship.
Yes.
donated in 1968. Where were you in 1968?
Lordship.
Where were you in 1968?
I was a kid.
You're the kid. Your affidavit says that you are 34 in 2025.
It was my uncle who has donated in the year 1968.
That's right. And where were you in 1968? Were you born in 1968?
No, Lord.
That's what I'm saying. So you're nowhere around.
Lordship, however, the right still exists.
I don't know.
Your Lordship, the state is yet to file an affidavit, but
So what
we
we
will
can
be-
do is, we can
Yes.
dispose of, you take a decision on his representation.
Yes.
Any representation filed? Any representation filed by you?
Lordship,
Take a decision on his representation in terms of the office memorandums issued.
Yes.
That's all.
Lordship,
Filed
however-
2018.
Lordship.
I'm challenging the appointment of respondent number 6 as well. Who was appointed without advertisement and selection process.
Your Lordship,
When was he appointed?
24.
Yes.
one query from the court, if I may.
Huh?
This, the petitioner is, nowhere in this document says that the petitioner herein is the landowner. The documents that the petitioner has provided in the writ petition are all recommendations from the landowner and also from the village council in the form of recommendations. Nothing saying that he's.
How is the landowner your uncle?
My father, elder brother.
But your father was also appointed.
He was appointed on
Yes.
general category. And that's not denied by the respondent authority as well.
Do you file your affidavit?
Your Lordship.
Mister? Huh?
M. Longkumar for the state.
M. Long Kumar, learned counsel for the state, shall file his affidavit within
3 weeks, Your Lordship.
3 weeks. This is the matter of 3 weeks.
Obliged.
Obliged.
For hearing, item number 17.
Yes, Your Lordship.
How much?
I have talked to the client. He is willing to at least
pay 25,000 per month for the past backlog, and then as a lump sum final settlement, he may be able to manage at least 30 lakhs. That is what he is saying. And
I think,
that also
I think you're also finding it funny.
reasonable, Your Lordship.
You're also finding it quite low.
Your Lordship, depending upon my means, only that proposal is placed before this honorable court. Because I
And how
cannot
much are you
make a-
expecting?
Your Lordship, in the maintenance petition, the petitioner is asking 2 lakhs per month for herself and 1.5 for each child.
Per month?
Yes, my lord. And that is according to his means.
That we'll have to see.
Yes, my lord. And that is the lifestyle that she has been accustomed to all these years that they were together.
Your Lordship, and the third is that the third condition is that at least the custody of the children. Right now they are in infancy, but at least after reaching 10 years, they should come to me, because they can never be the.
Now you've got another family.
Your Lordship, but the two children, they can never be the tribe of the mother. They cannot. They have to be my children. You know, even in government levels, for employment, for educational purposes, also, their tribe has become very important, especially in the context of the.
He has not paid his maintenance since when?
From the very inception.
When is that?
The first order was 4/3/24.
4/3/24.
Yes.
So from 4/3/24, 10 months last year. And this year, 11 months.
Yes.
21 months. That 60,000 per month is still subsisting.
No, it's subsisting.
And you pay that amount. You
Lordship,
pay that amount first, then we'll decide. Okay.
I'll leave it to your Lordship, but it ought to be according to my means, your Lordship. At that point of time, when the 60,000 was awarded, I produced my current income as 70,000 only. At that point of time, now it has reduced. It has come down, your Lordship, because I am unemployed. I may be a registered contractor, but it does not mean that I have steady income. This is the problem. Now it has come down.
You see, the thing is that you all remind me of when I was a lawyer. You remind me of when I was a lawyer. I remember this person, claimant, going to the MACT tribunal, for evidence. He went to the walk with this thing, with that stick, you know, with a broken leg, and you go chapter there. Walking, he walked in, gave his evidence. Then after he left the district court complex, as soon as he crossed the gate, he threw in his stick in the road. So
in my case, you're
so
not
with all your facial expressions,
Yeah.
you feel you look very, helpless and poor and everything.
You're right. In my case, it is that is a genuine because all the whatever certificates I had produced before the court was after based on the audit by the CA.
Okay, just tell
Chartered
me.
accountant.
So now, the Dunki village, they have passed this on.
Yes.
Okay. What happens if the two different communities marry? Whose custom are you going to follow?
Here, the man's custom. Your
How do you say
that is how
was the marriage done as per the man's custom? Was the man's custom followed while there was a
Yes.
marriage?
It is as per the pattern, we have, as per customary law, patrilineal.
That is only
Yes.
for inheritance, Mr.
Your Lordship,
Kasser.
but-
That is for inheritance and the tribes and whatever. But
Once.
when there is a
yes.
marriage,
Yes,
if there is no marriage as per customs,
yes.
how can there be a divorce as per custom?
The Naga custom, your lordship, is that once a woman is married to a person belonging to a particular tribe, she becomes that tribe.
To belong that tribe.
Yes, she
Is it?
becomes that tribe, yes.
That is true, Your Lordship.
Yes.
But at the same
It
time,
becomes
there's
a-
another aspect which is not being stated. We have never taken up residence in Dunki village. Never. Always in Dimapur.
No, but the thing is that will the customs in Dunki village and a neighboring village of the same tribe be same or different?
Different.
Villages.
No, if it is
different.
if it is the same tribe, then the customary law is same.
But different
But then
tribes.
generally among the Nagas, customary law is more or less same. Only when it comes to who gets what minor details in those cases, there may be slight differences, but otherwise generally customary law is uh, similar across all the villages.
Was there
all the
was
tribes.
there any divorce petition pending in some courts? No.
No.
I have filed a divorce petition.
That was after, no? After
Yes.
after the Dunki decision.
Custody case was already filed. Domestic violence case was filed.
Let us see your petition in the custody case. Let us see the contents of that,
The custody petition I have not enclosed here.
because that will give a pointer
Your Lordship,
as
yes.
to whether you had taken a plea that you all had divorced or you all separated or something like that. What did you say of that?
No, at that time he had deserted me and taken away the elder child.
So, what are the contents of your pleadings? I wanted to see that.
I have not annexed
The
them.
order itself contains the entire pleadings. The learned
no,
court,
the
the learned court has reproduced only the pleadings.
Okay, okay.
Yes.
Where?
In the order itself.
60.
In my affidavit.
Page 60. Page 60 of my petition. No, this is the modification order.
Page 40, Your Lordship. Page 40 of my affidavit.
No, one is saying 60, one is saying 40.
That is the subsequent.
That is subsequent order.
Yeah,
First order is,
subsequent order.
first order is page 26, ma'am.
When the Dunki Village Council took a decision, they heard you.
They issued a summons to me. I told them not to interfere. I submitted a representation asking them not to interfere.
Why? That because there was a case pending
Yes,
already,
because there was a case pending already.
a custody case.
Custody case as well as divorce petition. That also I
But
got.
divorce petition was later, after the Dunki Village Council.
Yes, my lord, it was later, but the summons was issued. So I told them that the custody petition was already pending. There's a domestic violence case pending. So the matter is already before the regular courts. So the Dunki Village Council should not interfere in the matter. First thing. Secondly, I said I am not subject to the jurisdiction of the family. So my representation was ignored.
So there are three cases right now. There's a domestic violence case.
Yes,
also.
my lord.
Yes, that was filed after the Tungi village took up the matter. After the Tungi village summoned the present petitioner, she filed a domestic violence case. And then based on that, she wrote to the Tungi village.
But the Dunki Village Council order is not based on every evidence.
Yes.
Yes, she was given time, but sufficient
But she
chances.
did not appear.
Three summons, she did not appear, so the Tungi village.
So you'll
the
go to
matter.
you'll go to the civil court, decide the issue.
Your Lordship, it is now,
if I may-
it is already, the divorce has been effected.
No, divorce.
Yes,
You see,
So
we will
far
not.
as
We will not. With regard to the divorce, that is not an issue because divorce. So both of you all want to divorce, correct?
Yes, both want to divorce, yes.
Huh?
Yes,
both
yes.
want to divorce.
That is the
Divorce
case.
part. Only problem is that the issue with regard to the decision by them as to who had abandoned whom or deserted whom, that we will keep it open.
Your Lordship, statements
That,
clearly.
that the family
yes.
court can decide.
Family court will decide that.
Family court will decide.
And we will say that both of them want a divorce. And as there no evidence was taken, and as both of them want to give evidence, let it be decided by the family court.
But now it will affect the second marriage, Your Lordship, the second marriage of the petitioner.
Married under what law?
The first marriage also the same, Your Lordship. As Your Lordship has
Your
pointed
Lordship,
out, the first marriage and the second marriage,
No,
Same-
Your Lordship,
same
as far
marriage.
as that line of
So-
thought, which Your Lordship expressed on the
Where
first
is
day, on that line of thought, Your Lordship, I was not expecting that question.
Ah.
But then I gave it some thought and then I did a little bit of work on that.
Ah.
Now, it would seem, my lord, that there could be a proposition that the Indian Divorce Act does not prescribe any form of marriage. The Indian Divorce Act. And it recognizes even marriages performed in other forms, including marriages performed in church, though not under the Indian Christian Marriage Act. There's an argument on that line, my lord. And I've done some work on that.
If that is the case, then that would support you.
Yes,
That
ma'am.
would support your case.
Yes.
To the effect that when there is no marriage done under the customary law, or under the Indian Christian Marriage Act, and when no certificate has been issued by under the Indian Christian Marriage Act, then the divorce that can be done as per your
the Indian Divorce Act.
Indian Divorce Act would be the proper
Yes, my lord.
forum.
Yes.
Your
The
Lordship, but
proper provision.
the marriage is as per custom only. Marriage is as per custom, after following
What
all
custom?
customary laws.
What
We
custom?
have our clan systems, Your Lordship. We have clan systems. Even across the various tribes, there are clans which have affinities.
So this
Those
custom,
kind of things.
how did you, how?
We have, the village has to certify that their marriage is possible. Only after that, the church solemnizes the marriage. Without those certificates, the church will not solemnize the
No,
marriage.
possible.
So-
You see, there's a thing, just because something is possible does not mean that something has been done.
Your Lordship,
You see, it's like saying, it is possible for me to eat that bastenga pork.
Your Lordship,
and I have eaten that pasta in a fork. It's two different things. It is possible. Possibility doesn't mean that I have done it. So just
No.
because the church has said that it is possible for them
No,
to marry.
not the church.
No,
The village
the
authority.
village,
Yes.
when the village authorities say that it is possible for them to marry, it does not translate into they being married.
No.
It only says that there was
Yes.
possibility.
But
So, possibility is neither here nor there. There's a possibility that I may become fat or fatter. That does not mean that I am fat
Yes.
or fatter.
these are,
There's only a possibility.
yes, these are not on the basis of written
So,
law.
you
Your
know, what
Lordship,
I'm saying
but
is that.
yes, Your Lordship.
So why don't you do a little bit more research? Then it'll be
Yes.
more clear
Be much better.
on the aspect of that Indian Divorce
Yes,
Act
my lord.
as to what it would cover.
Yes, ma'am.
If it
Yes.
covers all forms of marriage,
Yes, ma'am.
whether unrecognized or recognized or whatever, then the case can be decided.
Yes, ma'am. That point can be recorded, Your Lordship. We'll make arguments on that point.
Your Lordship, this is covered, even the village authorities are empowered under the Village Council Act to take up cases pertaining to customary practices.
It's very simple. It's very simple. When a marriage is done under the Hindu Marriage Act,
Yes.
can the village council annul it?
That is a different aspect because it is statutory law. It is based on the statutory law. The marriage is under statutory law. Yeah.
So, when a marriage is done, is performed under the Indian Christian Marriage Act, can
Yes.
the village council annul it?
The practice is like this. It is going on. It is going on.
Look, Mr.
Yes. Because customary law, Your Lordship, it is unwritten. So customary law automatically applies to all the
No, I'm sorry, you don't.
all these cases.
You
But
please
yes,
read.
but what is going on in the state? I am submitting before Your Lordship. Whether it is according to Your Lordship, it is acceptable or not, that is a different issue. That is a different issue. But the customary practice among the Nagas is that usually if there is an issue, the relatives first the relatives will take up the issue. If it is reconcilable, reconciled. If it is not
No,
reconcilable, then as per customary law, who gets what, they decide and then they part ways. This is how the Naga customary laws apply in our state without going to the court. Both the village,
What
but
is,
here in
what,
this case,
what is the customary law? What is the definition of a customary law according to you?
Your Lordship has given the definition of the custom on the last
So
occasion. it is that-
when did Christianity start in Nagaland?
But marriage, yes.
When did Christianity
Christianity
start?
was only 100-something years now. But
And the Nagas have been around for how long?
thousands of years since humanity began. So,
So-
the custom- yes.
What is the custom?
Even the marriage is done as per custom, Your Lordship. Even marriage is, solemnization of marriage by the church is done as per the custom only, Your Lordship. That is what I am submitting before Your Lordship.
So earlier in
Solemnization.
earlier
Earlier, it was without going to the church, both the parties should agree, families should agree, and then the home should be built. Then on a particular day, sacrifice is offered by the father, and then they enter
What
the
do
dwelling
they-
and
what do-
they
what-
are husband and wife. That is, they are husband and wife. They are validly married. That was the earlier custom. But since Christianity came, solemnization is done by the church. But the church cannot divorce the parties. If at all there is a divorce, the report comes to the church, whoever is the...
if church cannot divorce a party,
Yes.
can church remarry a person? Let him have a second wife.
Your Lordship, that is a practice. This is the settled practice, Your Lordship.
No, I agree. No,
Yes, this is a settled practice.
you've got to make sense.
Yes.
You are saying that a church
Yes.
cannot divorce a party, correct?
Yes.
then can a church allow a second marriage of a person?
For that, they have to get confirmation from the
Is that a
parties whether-
custom?
Yes, whether the parties can again marry or not. For example, if there's a divorce, if one party is guilty, the church will excommunicate
And
him or
divorce
her.
done by whom?
And will not-
Divorce done by whom?
Your Lordship,
Divorce is done by
done by like I have submitted. The relatives come together first. The relatives will try their best. If it cannot be reconciled, then they divorce. But according to custom, who gets what? The relatives, they know the custom, so the division is done. Matter is over. The report, whoever is in the wrong, that report will be given to the church. If both the parties are in the wrong, it will be given to the church. The church will strike off their name. They are excommunicated. Now, subsequently, unless the church allows their name to be re-entered, they cannot marry in the church. The church will not allow their marriage. But if one party is found in the wrong and his or her name is cut off, the other party can remarry in the church. This is a practice in our state. This is how it
There's a difference between practice and
Yes.
custom.
Your Lordship, the custom is the relatives will take up. Only in case of.
You see, what is the definition of
And the
custom, you
priest
know?
also.
You see, custom is that has been happening from time
Yes.
immemorial.
That has been that is
When your church marriage has happened from only 100 years.
Only recently. That is only recently.
So it is not a custom.
It is just a right.
The
Yes.
first condition, it fails.
Yes.
Then it is not a custom. Triple.
No, that marriage in the church is not a custom.
Correct.
That marriage in the church is not a custom. That I accept, Your Lordship.
No,
But the marriage between the spouses, whether it is inside the church or without the church, it is still a marriage. For example, some people they just
How do you
live
marry? How do
together
you marry outside the church? Supposing that
Yes.
that Naga couple are not Christians, how will they
Yes.
marry?
They just come together, the families agree, and then they live together as husband and wife. No registration, nothing as such.
No, I'm not.
Yes.
Is
yes.
there some ritual?
No ritual,
No.
normally. It's the ancient practice of offering sacrifices is done away with. Only
Done
that the parties, both the families come together and then they are treated as husband and wife. And it's recognized as a valid marriage. But if it is done, if they have membership in the church, in order to maintain the sanctity of marriage, the wedding is solemnized in the marriage. That is
Yes.
that
Is there some ritual
Pardon me,
for ritual, customary marriage custom?
Before,
Yes.
yes.
Okay.
But now no more. Now no more. Now it's
No.
all the Christian practice now.
Yes.
But in any case, Your Lordship, 1986 GNR clearly says 371A is not an argument to advance as far as marital disputes are concerned.
So in extreme cases, the village takes up the cases. Like for example, adultery, then in that case,
Para?
Worship, we can come straight away to page 305. 305? 305.
Yes.
And in the middle of the page, the contention of the Learned Council relying upon the provisions of Article 321A of the Constitution, providing that no act of parliament in respect of Naga customary law and procedure shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decided need not detain us long in view of the express provisions of Section 26 of the State of Nagaland Act 1962, and the further fact that the Indian Divorce Act 1869 is not an act of parliament to which the provisions of Article 371A of the Constitution are attractive. Then the next paragraph is also relevant, Your Lordship. It is lastly argued that it is the duty of the court when both the parties to the litigation are indigenous inhabitants of Naga Hills, to make an endeavor in accordance with the letter and spirit of Rule 30 of the Rules for Administration of Justice and Police in the Naga Hills District, to induce them to submit their case to a panchayat. The Learned Council invited our attention to the decisions of the Assam High Court in such and such.
Just a minute. And lastly, there is a duty of the court to impose. Then this is not in your favor.
Which one, Mano?
The subsequent paragraph.
No, there it is. Your Lordship can come to the end.
Okay.
Come to the end. In all these cases, the learned judges held that the parties agreed to a panchayat, then the procedure prescribed under Rule 30 should be followed. Yes. In this case, the Additional Deputy Commissioner in his order clearly held that where the parties are unwilling to go to the customary courts, the court cannot compel the parties to go to the panchayat. I'm not willing, man. I'm not willing.
Your Lordship, the acts of the state government, it's very conflicting. Here under the Village Council Act, the village is empowered. to
I am
take
bound
up these
by this
cases.
judgment.
Yes, Your Lordship, Your Lordship, I am only stating the law that is in place in our state. These conflicts with maybe this was not brought before the court. At the time, it was
not brought before which court?
Your Lordship, the village courts. A village court shall try all as per the Act, Nagaland Village Council Act. The village is authorized to try all cases following customs and usages applicable in deciding such suits and cases. The village is
Let us see
authorized
that.
by
Let us see that.
the Nagaland.
The rules there. The rules of 1937, Your Lordship.
Your Lordship,
So this
is
is
a
this
compilation
against you.
Yes, Your Lordship, but this has not been discussed in the judgment, it appears.
Let us see.
Yes,
If
Your
that is-
Lordship may.
So that is the only case. This has not been discussed.
Yes, this has not been discussed and this is a compilation by our former Justice Zellrin.
It's just a compilation of
Yes,
the
but
rules
the
with all
acts-
the amendments.
acts- all
With
the
all the
acts,
amendments.
Amendments that had,
No, this is only a general.
yes.
Only a general provision.
No,
It has nothing
yes,
to do
but-
specifically with regard to the Indian Divorce Act.
No, no, but
And then the
my
Family
my-
Courts Act, Your Lordship.
Yes,
The
my
Family
case
Courts
is,
Act, all marital disputes are not before family courts, no other courts.
So family courts have been created in
yes,
Nagaland.
yeah, it has been created in Nagaland.
What is the purpose for the Family Courts Act? What is the purpose?
But even under the Indian Divorce Act,
Council.
I would submit.
Please
Your
answer
Lordship.
the question.
Yes, family courts have been set up to take up family matters, Your Lordship. But there are also customary practices which are taken up by the villages, Your Lordship. This is what I'm saying. And this falls under personal law, especially
So?
marriage,
So,
divorce and all. So now, and as Your Lordship has rightly pointed out, this marriage, if it is to go by the Christian Marriage Act, it is, that issue is there. Now, in my case, because the wife has deserted, and I have also, if Your Lordship may go to one paragraph, the pastor himself, who was specifically agreed upon by both the parties to take up the issue for a reconciliation.
No, you see-
They have tried, they tried their best, but since the petitioner was not responsive, they gave up. Now the petitioner had no option, the respondent had no option but to move on with his life. He cannot remain like this. So ultimately, even without approaching the Tungi Village Council, the divorce is done by the wife leaving the marital home.
according to you.
As per practice, as per the
According to the
Naga
wife,
customary.
according to the wife, you are never home. You are always out partying.
No, Your Lordship will
Huh?
see, Your Lordship will see my statement in the order itself at page 27 of the
Look.
order.
Let us not.
That is her allegation. That
Just
is-
a minute. Just a
that
minute.
is her
Just a
stand.
minute.
But my case is also.
Just a
yes,
minute.
Yes.
Take it easy.
Yes,
You've got to hear things also.
Your Lordship.
See, there's no point going round and round the
Yes.
bush. You know? We have seen Hindi movies, we have seen.
Your Lordship.
There's no point going
Your
round
Lordship.
and round all the time. Now the issue is this. The issue is whether the village council can issue a decree, a divorce decree in a way.
Your Lordship.
Okay. Now the High Court, Gauhati High Court, has held that it cannot.
Your Lordship.
I mean, it basically says that the Indian Divorce Act will apply. Now, so I cannot
Your
go
Lordship.
beyond that.
Your Lordship.
Or if I disagree, then I'll have to send it to the reference court. I don't find anything to disagree right now.
Your Lordship.
Now the problem is, if we set aside the village council order, you will be having two wives.
Yes. Yes.
So the only way I see it is now we have got to be practical.
Yes, Your Lordship. That's
We can uphold the divorce because you both want it.
yes.
But the manner of the divorce or the reasons for the divorce, we can let the family court decide.
Your Lordship.
What do you say?
Your Lordship, if the village council has no jurisdiction, no question of upholding it.
But the problem is that he'll be
Yes.
It's his lookout, Your Lordship.
Huh?
It's his lookout. He put himself in that position. So this, my humble submission, with the greatest respect, my lord, the problems between the parties should be left between the parties. This Honorable Court should not take on the task of giving some semblance of propriety to what has been done.
No, we're not giving propriety. You see, the thing is that we're trying to settle the issue.
Right.
Now, when you look at the mediation, and there's so many things going on, the ADR and even in the Family Courts Act,
Yes, ma'am.
there has to be an attempt at settlement to be made.
We did try.
No, you did try, but the court also can try.
Of course, yes.
Now, because of the Pickwick situation that will arrive, that is why this court had tried to settle the issue between you two. If you can agree to a lump sum amount of compensation to be paid, then everything would have been settled. And we wouldn't have to go and, open up a Pandora's box now.
No.
So for that reason, now you both will have to decide. I think you have to raise the bar. Oh, yeah.
Your Lordship, unless they bring their proposal and
your proposal
some-
also cannot be monthly. It has to be at one go. It cannot be monthly. Monthly, you see, monthly, it's always subject to change. Today
Yes.
he may be a rich person, tomorrow he'll be a pauper. Could be. I'm not saying he'll be, could be. Or the other way, he might become a billionaire. We don't know. But either way, it's a very unsure thing. And kids after 18, whether they have any right, that's another issue.
That's entirely up to the children after that.
So those things are there. So it's better if you all can come to a settlement between you two with regard to a fair settlement. How much are you willing? That's what you are saying monthly, without monthly. How much total?
The problem here, my lord,
Give me a figure.
The problem here, my lord, as I was submitting on the last occasion, the decision of the village council is coming in the way of negotiations. The respondent is under the impression that he has got no responsibility whatsoever, and the village council decision
No, I
favors
have
him.
told him.
Yes.
There
If
is-
this court can pass an appropriate order to the effect that
no,
the
it's-
second
it's-
marriage is not affected, Your Lordship.
No,
That is
that is why
that is the biggest problem
you
here,
have
Your
to,
Lordship.
for that.
Yes.
You'll have to show your second wife that you love her very much and say that, look, for you, I'm giving this much money.
Your Lordship, my proposal, I have put it put before the table.
You
Yes.
do it for the love of your second wife.
Your Lordship.
Don't do it because you hate the first wife, but because you love the
Your
second
Lordship,
wife.
Your Lordship.
Then you can tell your first wife, it is because of my second wife I'm giving you this.
Your Lordship. So long as it is.
Let us see
within
how
my
cheap
means-
your love is or how You know, deep your love is.
Your Lordship,
Yeah.
yes.
So you cannot have cheap thoughts when you think of your.
Let them also bring their proposal and whether, what extent
How much?
that can be.
How much do you want?
Yes.
Be reasonable. Also.
Please.
It cannot be.
I'll have to
Yes.
discuss that again with her.
Yes, because you see at the end, like, you're correct. Legally, though, you seem to be in a
Yes.
strong footing, or with a
Yes.
strong wicket. But then we pass that order, is going to
There is a
cause
human
some-
problem left.
Yes.
Yes.
There is a human problem left. I
Yes,
agree,
yes.
man.
So, yeah, if we can settle it, so you also think about coming to a reasonable figure, a lump sum figure. At one go, everything should be settled.
Yes.
When,
Next week, my lord.
Your Lordship may record that regarding the settlement issue, so that whoever comes, since Your Lordship will be,
okay, right.
yes.
Heard the counsels for the parties. On considering, on considering the, no, after hearing the parties, this court is of the view that an attempt to settle the dispute between the parties can be made if the focus is shifted to payment of a permanent alimony by the respondent to the appellant. In this respect, the counsels for the parties shall obtain instructions from their clients with regard to a reasonable amount that may be, and the reasonable settlement amount that may be payable by the respondent to the appellant. That's all?
To the petitioner, my lord.
Huh?
To the petitioner. Not that, to the
Oh, to the
To the
petition.
petition.
List the matter on when?
Monday?
Monday.
Your Lordship.
You have come to a reasonable figure.
Yes.
Don't be.
But it will all boil down to what
Look,
he
one thing,
wants.
one thing. You've
Then
got,
I will also inform my clients, yes.
you're on a weak wicket.
Yes.
Your wicket is weak. Plus, you have got two kids who are going to need
Yes.
money now. School, everything, you know. And
I know,
so
Your
you have
Lordship.
got to raise the bar.
Your Lordship. I have also told him that, but then according to what he may be able to, he has given me that figure. But then if after they bring their side of the proposal and if the court has settled, middle ground can be achieved,
So
then
you bring a
that will be very
You
good.
bring a figure.
Yes.
You bring a figure, then you know, by negotiation and something. I think it
Yes.
can be settled. It should be settled.
Well
Yes.
done. We'll do that.
I also want this matter to be over and done with.
I wish his client is
Yes.
as forthcoming as him, my
Yes.
lord.
No, but
even my client is also.
Tell
he
your
is also-
client, as per the decision of the Gauhati High
Yeah,
Court.
Your Lordship,
Yeah.
I have already discussed that.
Okay.
But the problem, like Your Lordship has pointed out, he has had his second marriage now. And if that is to be interfered with, now both parties, she also wants divorce.
So
Now,
you-
if that
you-
happens,
so
then
you give
yes.
some money.
I willing to, but it has to be within
Reasonable.
reasonable. It has to be reasonable. It cannot be.
Give it with love. Not the first wife's love,
Yes.
second
He
wife.
wants his children also. But then what to do? Law.
Much obliged.
Okay, just a minute. Yes, okay. Oh, overflow. One more matter.
For hearing item number 18.
Yes, Mr. Counsel. You are the only daughter of your parents, correct? You've got two others. And how old are they? You are the youngest. Your mother died when? Two 2009, your siblings, you've got any sister? You've got a sister, married, married. And she's married. Married when? Your elder sister. Your elder sister got married when? Which year? Anyway, that. You see, Mr. Kaul, it's very difficult now. There's who? Oh, that means she's 60-year-old now. Yes, yes. Please. Yes. Yes.
In this judgment, the court say that writ petition cannot be moved by other person. So in my case, if we go by this, then there's no.
Please read.
Generally speaking, a person should have no locus standi to file a writ petition if he is not personally affected by any order or his fundamental rights have neither been directly or substantially invaded nor is there any imminent danger of such rights being invaded or his accrued interests have been violated, ignoring the applicable rules. The relief under Article 26 of the Constitution is based on the existence of the right in favor of the person invoking the jurisdiction. The exception to the general rule is only in cases where the writ applied thereof is a writ of habeas corpus or filed in public interest.
So it comes under which of these three? Your case comes under which of these three?
In this case, the decision is not correct. It's not correct. But the procedure and the manner in which the court has taken up is related to matters.
Let us see.
Suffice to say, the original writ petitioner was one of Mr. B.K. Degas. He was working in military services and was commissioned in the Corps of Electrical and Mechanical Engineering in 1970. He was then posted to Headquarters Director General of Armed Forces, Shillong as GAP in 1980. Where he faced court-martial proceedings on charges and verdicts. This led to his dismissal from the service. He then challenged the court-martial proceedings, including his dismissal, ordered by filing writ petition number 24 before the Delhi High Court. This writ petition was transferred to the tribunal on becoming in force the act and was registered as EA number 24. During the pendency of the matter before the tribunal, Mr. So-and-so expired, leaving behind his widow, his son, and daughter as his legal representative, who were brought on before as the petitioner therein to continue the proceeding situation. In this case, during the pendency of this petition, the petitioner expired. So I pray that I submit that the legal version of the deceased petitioner bring to the report.
No. You see, out here in the case that you just read, the rights of the legal representatives remain. Because if they won the case, then the wife and the kids would have a right to the family pension. In your case, no one is left to enjoy family pension and no one can have a claim to family pension. Yes, yes, sure.
There are 11 are in page number 11, paragraph 31.
11 and 10, 11 and 12, page. Page 11.
11.
Yes.
Paragraph 31.
Yes. Yes.
We are not inclined to accept the contention of the learned council or the respondents by the reference to the material provisions in the pension rules. We have already indicated that the ground of pension does not depend upon an order being passed by the authorities to that effect. It may be there for the purposes of quantifying the amount having regard to the period of service and other liabilities. It may be necessary for the authorities to pass an order to them, but the right to receive pension.
We'll take it up at 2. We'll take it up at 2.
I beg your lordship indulgence to make a mention. Item 13, I was at court number 2 when the matter call up.
Item
Item 13,
13.
yes, I was at court number 2, lordship.
Yes.
Lordship, may I bring that this matter released Monday?
No. We'll do it a small matter. We are fixing two of the matters tomorrow. Same.
Different.
It's the same issue.
Item, lordship, item. The other two items, there's slight difference between these two items. lordship.
Your item is also after retirement, you have asked for regularization.
I'm not claiming regularization in terms of the office memorandum, lordship. I'm claiming regularization for pensioner benefits in terms of the
Correct.
lowly on the apex court, lordship.
Correct.
And the other case, lordship, they are claiming regularization in terms of OM up to the 17th, by which it has been provided that a person after completion of 30 years, they are entitled for regularization. That is the issue in other two cases. Here in this case, I'm not claiming any regularization in terms of any office memorandum, lordship.
Then under what law can you be regularized?
Lordship, my case is covered by this apex court judgment in order, lordship.
Which judgment?
Brahim Singh also, dear lordship.
What
And
does
other
it
two, a division bench judgment of this court. However,
We'll
lordship,
take it up tomorrow. You see, it's a small thing. You just send your junior with those two judgments, three judgments. You see, the issue is this. When there is, you see, now the problem is.
Actually, I've submitted my representation. When I was.
So what we can do is, best we can do is, we can tell the government to decide a representation.
Lordship, immune order already been issued.
Huh?
Immune order. There is immune order in my petition.
Okay.
My claim for regularization has been rejected on the ground that my case doesn't come under the office memorandum of 2017 and 2004. Yes,
Okay.
that is correct. I'm not claiming my regularization on the basis of the OMs.
And then?
Therefore, my case is covered by the decision of the Supreme Court. Lordship.
What is the Supreme Court decision?
Lordship, 2019, Brahim Singh case, Lordship.
2019, yes. 2019.
Then ACC, Lordship.
Which SEC?
Then ACC.
Then SEC.
And 1997.
No, which page?
516. And 1997.
2000?
1997.
1897? 1987.
1997.
1997.
2 GLT.
2 GLT.
209.
209.
And judgment and order, Lordship, dated 6/2/2024.
24. Passed in?
Passed in WA number 35.
WA.
WA.
WA number?
35 of 2022.
22.
Yes, Lordship.
Okay.
My case is covered by these three judgments.
So let us see.
In fact,
Let us see that. So we'll see. I'll see this judgment, and tomorrow we'll see. Let us look. The only thing now, your case is based on these three judgments.
Lordship.
That's all. You retired in 22.
Yes, Lordship. And I came to because there is no bare information.
And you made an application. You made this repetition only in 25. That's all.
Yes.
Now what is to be considered?
Tomorrow.
That's all. You see, another thing.
Tomorrow I have some personal difficulties.
No, your junior, let it be there. Your junior, you're not. We'll
If
take it
not,
up.
we can,
We'll take up your
Lordship,
case
we can
now.
take it up
We'll
now.
take it up. Just give me item 13. Give us the judgment. Let us see the judgment. Yes, where's the citations? Listen.
Before I refer to judgment, Lordship, may kindly come to my paragraph 4 of the
Yes,
petition.
yes.
Paragraph 4 and 5, I'm just referring to 3 paragraphs, Lordship.
Yes.
May I read, Lordship? Paragraph 4. That the petitioner begged to state that she came to know about the said release order only in the month of February 2023, when the department stopped payment of her monthly salary, and as much as no better information, notice has ever been circulated showing her date of retirement. Without asking me on receipt of the release order, the petitioner approached the concerned authorities to regularize her service for purpose of mentioned benefits. The school of your petitioner covered this declaration on transportation and paragraph 30 with regard to submission of representation before the
Yes. Yes.
Now the petitioner may extend that political service day. The petitioner on several occasions approached the authorities to provide hospital as a new petition for regulation of her service in terms of the policy report and from which was not considered. The disposal authorities also realizing the petitioner releasing the petitioner from service without restriction. Although taking a stand that the petitioner cannot be regularized prospectively in terms of the law. The line report. Such election of responsible authorities will go.
Yes, where is your representations? Where is your representation submitted by you?
After, before I was released, I submitted a plea which was not the custody of.
Where are they?
It is before it. And after retirement of my passenger.
Page 27. Page 27. No, after retirement, no use.
Setting the very city of the state in 13.
No, there is, you see, this page 27. On receiving the release order, I approached the authority to regularize my service.
Yes.
There is nothing stated here that you had applied earlier. Acha, wait. During my service, I approached the But then you have not filed the case prior to thing, no? Prior to your retirement. You have filed it after your retirement. Okay, let me ask you a simple question. From what date are we supposed to regularize you?
Ask her to do more of this in the credit. At least the department will consider.
Let us see the 2004 regular memorandum.
Page 34.
Yes. But then you see, you have been sleeping over your right, the 2004. You retired in 22. Let us see your judgments of Bhim Singh and whatever. Two thousand nineteen 10 SSC. Yes, para? Page 541. Yes. What it says, employees in work charge putting in 30 to 40 years. And you? Not 30 to 40. You're a principal. So 30 to 40, will 30 to 40 also include 10 years? Where do you draw the line? No, the problem is, why haven't you made a claim? Why don't you make the claim prior to your retirement? After your retirement, then also you retired in 22. You have filed a writ petition in 25. Now you see one thing. Now your regularization is going to be done from which period? From which year? Huh? Okay, supposing your regularization is say 1 day prior to retirement. Now, 1 day prior to retirement means in say in 22 itself you are regularized, or 21 say. Now, if you are retired in 2020, you are regularized in 2021. Now, what pension rules would be applicable to you? New pension rules or the old pension rules? Why? On what ground? How can you be the how can the old pension rules apply to you? So what? So what? Uma Devi's judgment was passed in 2006. And in 2005, the new pension rules came into effect. So you could not have been, and by 2006, you should have had 10 years of service. You were appointed in 1998. So you could have been regularized only after 1998. not prior to 1998, because 10 years of service you did not have, as per Uma Devi's judgment. And in 2008, new pension rules came into effect. Prior to that. That means now, as per the new pension rules, the pension is calculated by, is made up of the contribution made by the worker and a matching share given by the government. Now, where is your contribution for that new pension rules? We'll allow, you give your matching share. How much? And can you ask the government now to turn the clock back and pay you pension from 2021? And that will be only for the matching share. There's no cost that 1972 pension rule does not apply. As per the new pension rules, you have to give, say, if it's 10 rupees, you have to give 5 rupees, government will give 5 rupees every month. And then when you retire, you'll get the entire contribution. So I do not know if it is going to help you at all. There is no family pension business in new pension rules. The new pension rules provides that I pay some amount, government will pay matching share. And then the total combined investment that we have made, deposits we have made, that will be taken out during the time we retire. So think of that also. We'll record everything. We'll grant you time, we'll record everything. How does it help you? I don't know. Correct. Your case is bad in a way. Compared to those cases, they have got the OMs in their favor. Those the council doesn't know, did not know, did not read. What research do you want? You tell me straight away, just thinking about it also. Just thinking about it. The issue of regularization of contract employees or the temporary workers came into effect with the judgment of Uma Devi, which was decided in 2006. Your 10 years, and Uma Devi says that the contract employee or those master role workers should have completed 10 years in 2006. In 2006, you had completed only 8 years. So you are not covered by Uma Devi's case. Yeah, bench hunting. Bench hunting, they said you should not allow bench hunting. Supreme Court has said. Now what to do? Should I go against the Supreme Court judgment? I cannot allow you to bench hunt. So, madam, have you heard what I said? What will happen if the first issue is from when should regularization be allowed? Supposing even if we allow it, from when? Okay, supposing we allow from the date of our retirement, and his only claim is pension. So, and as per the new and date of retirement would be 22 in the year 22, and in the year 22, the new pension scheme was applicable, not the old pension scheme. As per the new pension scheme, I have to give 5 rupees, government has to give 5 rupees. And when he retires, he'll get that entire 10 rupees. Now, if he's going to, on the date of his pension, I do not know how much he has to give, maybe 500 rupees. You give 500 rupees, he gets 1,000 rupees. That's all. He doesn't get anything beyond. So how will it help you? I don't know. It's a new pension contributory fund. It cannot be. It cannot be. Your claim is wrong because for the simple reason, from when did you have a right? From when were you regularized? It's from the date of regularization. You cannot say that I should be regularized from the date I was appointed. If you say that, why have you slept over 24 years or 28 years? Delay latches, the repetition is thing. You see, the thing is that even if I adjourn, the problem is the law remains the same. He's not claiming that. He's saying that he just saying that because he has worked for 24 years. That does not exist. The submitting of representation is of no use. He has got to file a writ petition. He has got to make a claim before the court during his service period. Filing 20,000 or 2 lakhs representations during service period is of no use. 1 representation or 2 lakh representation does no use. You have to come to the court. Anyway, right. Heard Mr. Vati Jamil, the learned counsel for the petitioner. Also heard Miss Learned. Okay. The petitioner's prayer is to set aside the letter dated 18/6/2025 issued by the Undersecretary to the Government of Nagaland, wherein the respondents have taken a decision not to regularize the service of the petitioner for the purpose of pension benefits, on the ground that the OM dated 17/3/2015 and OM dated 22/9/2004 are not applicable to the case of the petitioner. Next paragraph. The petitioner's counsel submits that the petitioner is not making a claim for regularization in terms of the OM dated 22/9/2004 and OM dated 17/3/2015. His only prayer is for regularization of his service on account of the fact that he had worked for 24 years in the office of the executive engineer, irrigation and flood control, Nagaland, till she was released from service by order dated 15/12/2022. He submits that the petitioner seeks regularization only for the purpose of grant of pensionary benefits and no other claim is being made by the petitioner. Next paragraph. Ms. So, Leonard Counsel for the state respondent submits that the petitioner having approached this court 3 years after his retirement, seeking regularization, the writ petition suffers from delay in latches. Further, even if regularization was to be, further, full stop, as the petitioner has slept over his rights, the petitioner's service cannot be regularized after his retirement. Next paragraph. The facts of the case is that the petitioner was initially appointed as a works charged Mali with a pay scale. Okay, with a pay scale. By an order dated 22/4/98 in the establishment of the executive engineer, irrigation and flood control, Nagaland. Subsequently, she was reappointed as Khalasi with pay scale by another order dated 25/8/2005. The petitioner rendered continuous service for a period of, the petitioner allegedly rendered continuous service for a period of 24 years till her release from service by order dated 15/12/22, on reaching the age of superannuation of 60 years. As can be seen from the submission made by the counsel for the petition, the prayer for regularization has been made only for the purpose of grant of pensionary benefits. The petitioner has filed the present writ petition on on 1/10/9/2025. How about that is after nearly 3 years of her retirement, of her release from service. The first question that is to be decided is to be whether the petitioner's service can be regularized, and if so, from what date. Even if the petitioner's service was regularized one day prior to her retirement, the question arises as to whether the petitioner would be entitled to pension under the CCS pension rules 1972, or as per the new pension rules, which is a contributory pension paid by the employee and the employer. on the prayer of the Petitioners Council, this is the matter in the next week. So that's what I'm saying, no? What remains actually? There's nothing, maybe you'll get maybe if 200 rupees, 300 rupees. That's all. Because for 1 day of regular service or 1 month of contributory pension, there's nothing. That's all. It's just, what will you say next week? I don't know. Because you see, I can understand if the 1972 pension was still there. But when the new contributory pension is there, then there's nothing for you to get. Otherwise, the only thing you're going to do, they're going to adjourn the matter time and again. Okay, so they're there. Okay. Huh? No, you see, one thing is that maybe the government is not looking at that issue. Because even Supreme Court judgments, they say that pension should be given. But then they forget that, I mean, sometimes it is forgotten that new pension rules are there. Because new pension rules, I think new pension rules are applicable in Nagaland. No? Are they applicable? No, since pension rules still applicable. No, it is applicable for those prior to the coming of the new pension rules. Okay, for those it will be applicable. But for new appointments and new regularizations, after the coming of the new pension rules, they are governed by the new pension rules. For, say, for a person who is going to retire today, he must have joined prior to 2000. He will be applicable to get the 1972 pension rules. Right, this is the matter to make. Yes. So you are relying upon what are the judgment? You are relying upon the last one. This Deokinandan Prasad versus State of Bihar pension. Para 35-36. Is it? 32.
31, 32. The question was the detention granted in a public servant's property affecting Article 31 clause 1 came up for consideration before the result High Court in Mohammed Singh versus Union. It was held that such a right in speaking property and any interference will be the breach of Article 31 against of the Constitution.
Mr. Counsel, the problem is she has died. What remains?
Lordship, my humble submission. But this case is different. In the first case I've cited, says that other than episcopals and four, we cannot apply. But my humble submission is that this is a property. The entitlement of the
It is the entitlement of the deceased, maybe. If we find her to be the daughter of the government servant. It is only her property, no one else's property.
It is only her.
And there has to be after decision of the court. Now the court has not decided. This court has done.
Lordship, I agree with you. It is only her. No other person can claim unless decided by succession. It is only her property. Not even the legal government, not even the legal dignity. It has to be decided by the succession court.
But her property should be determined. Whether these errors are her property or not is the question, Lordship. That is the question, Lordship. The errors.
Your basic case is that it is her, one, the decision should be taken. And if it is found that it is her property should go to her sister.
Lordship. Lordship. Her sick leaves or her successor has the right to claim the property of their sister. That is my humble submission. That is my point. And this is the property. That is why the matter can be pension matters can be decided by the tribunal. Or else, if it is not a property, then in every matter, had I been a central government employee, my case or pension case, my case has to go to the court. Had I been an employee of the West Bengal government, then my case has to go to the court. But here in my case, I don't have any alternative remedy. That is why I invoke writ petition. There's no other alternative remedy like tribunal or other formula to adjudicate my case. I don't have any other alternative remedy. In the case I've cited before, in that case, there are other alternative remedies. That is why other person cannot invoke to seize for the right of others.
You see, it's not so simple. It is not like this is pension, family pension. Only belongs to that person. It cannot be transferred. I cannot transfer my family pension to somebody else.
My humble submission. As per this judgment, pension is a property.
Pension is a property, pension is a right for that person only, not for others.
Lordship, say for instance, of my humble submission.
Your humble submission is, who is the petitioner? Who is the petitioner? The petitioner is a dead person or a live person? Huh? What? Dead person or a live person? So you file a writ petition by a live person. Can a writ petition be decided in favor of a dead person? No, Mr. Counsel, please, let us go. Humble submission, that humble submission will always be there. Whether it's really humble or not, that's a different issue. You see, the thing is that, can a writ petition be filed by a dead person? End of the matter. So if you think that you have a right, if you think that you have a right, not you, I mean, if you think that your sister has the dead writ petitioner's sister has a right, let the dead sister file a writ petition. Not how can I decide against all, how can I decide a writ petition where the petitioner is a dead person?
That is why my submission. In the manner followed in this case, I pray that the same manner be applied and the legal guardian of the deceased petitioner.
But you'll have to show then what is your right to the property? What is your right to till a decision is made as to whether that property should go to this dead person. Only when a decision is made that the property is to go to the dead person, belongs to the dead person, then it's not so easy.
In order to determine whether the deceased petitioner is actually entitled for errors, that the legal guardian of the deceased petitioner be called without closing this case and issued. And after the determination of the entitlement, the property, that this amount belongs to the deceased petitioner, whoever is the successor and entitled the right to successor can come to claim. And that claim has to approach the succession point.
I don't know if it's correct, but it's a food for thought. Yes, what do you say? That issue has not been decided.
She has no control.
Who is the legal representative?
Our eldest sister.
Uh,
Lordship, I agree that her entitlement is yet to be covered. That is why my prayer. Her entitlement be decided. That is my only prayer without closing this case. Let that be determined.
No, but then doesn't the case abate with the death of the person? I don't think that anything remains.
That's such, Lordship. That's not Lordship. In this manner,
Okay, let me think about it. I will think, I'll put it CAV. Let me think about it. If an issue which has been undecided can be decided even after the death of the writ petitioner.
because this is an undecided property of the deceased should not go away with her demise.
It will go to the state.
No, Lordship, if she is alive. Because during her lifetime, he applied for family pension. He applied for family pension.
You see, the problem is your judgments are not your judgments are not to the point. I will do some research. I will. It's an interesting point. Don't worry, I'll try to be fair. It's an interesting point, but I basically you want the sister to have a share, so that so some good material instructions are there. But but we will see. We'll see. We'll have to do some research as to whether it can be done. Because you see, when a writ petition is filed, it is for an enforcement of a legal right. So we will have to see when a issue has not been decided and a writ petition dies, does the cause of action die with the writ petition? Because the property as on date has not been decided in your favor.
Yeah.
Correct.
Yeah.
Correct.
Yet to be decided.
No, but then she's dead.
Yet to be decided.
So she's dead. What is to be decided?
That's all.
So that has to be seen. Let us see.
That's my humble prayer. Let it be decided. Without closing this.
Yes.
Entitlement based on verification.
Ah. What verification? Oh, where is that? Where is that? In the family declaration. Eight, just a minute, just let me see this order. 8, 9. No, the issue is basically, is she the daughter of the deceased government servant? Or for that, she had to go for verification. So that has not been done. Oh, so that issue of whether she is the daughter has not been proved. Oh, I thought you already proved in a way that you're the daughter, but the issue. Okay, so there is some Manipur court declared you, no? Had declared you the daughter.
Decree the petitioner that the deceased petitioner that she is the unmarried, disabled, legitimate daughter of the deceased and the family court has decreed. And I have also annexed the disability certificate issued by the state medical board. The state medical board for issue of disability certificate government of in your affidavit in position, they have never questioned this, they have never, at any point of time, they have never disputed this. The disability certificate issued by the government of Mahamud sufficient. So the state of legal propriety, the state of Nagaland is expected to appreciate and accept this document.
No. Sometimes you've got to prove the document is true. You see, you've got a lot of MACT cases in Nagaland from Bihar. I think you know MACT cases. Why should they file it here in Nagaland? They could have filed it in Bihar, they could have filed it in Assam. You've got to prove the documents. You've got to prove that the documents are true. You see that all those documents have to be proven to be true. That is the problem. Otherwise, we cannot accept all documents just like that.
Certificate has been also issued with an authority.
Maybe.
With an
But it has to be proved by way of evidence. It could be a forged document. There is a thing called fabricated and forged documents. Just a minute, just let me see if something can be done or not. Just a minute. Where is that Manipur court order?
Page 22, next chapter.
In the family court. You see, the problem is, government of Nagaland is not a party here. You are fighting a case against the government of Nagaland for pension. You have got to prove to the government of Nagaland that you are the daughter. So government of Nagaland should have been a party. So when the government of Nagaland is supposed to give you pension, if they are not a party in the declaratory suit filed by you, can that order bind the government of Nagaland? So that has to be proved, nah?
This judgment has the petitioner approached the committee for number secretary.
Yes. And all these persons, who are all these persons? Who are all these? These are all your brothers and sisters or something like that. Then, Mr. Counsel, I can go file a declaratory suit and I'll make the defendants my brothers and sisters and my uncles and aunties. And I pass an order and the court passes an order, declaratory suit. Can I make a claim on the basis of that against you? Will it bind you?
In this case, the case is not against anybody. This is just to show a document to prove that I am the legal and biological daughter of the decision board. Just to show that.
I agree. But to show that, you have got to make the party against whom you're going to claim something a party, no?
This is a big case and it was not the case. The government was not to prove to the government that she is a defendant. Of course, even if she had the judgment of the Supreme Court, taking that she is the daughter of the district employee, Chief, the representation.
You see, when did you make the claim for family pension? Which year? No, just I want to know which year, 2000?
I
2019, you made a claim. When did your mother die? 2009, your mother died. And you make a claim for family pension in 2019, 10 years later. And then you go to the Manipur court in 2021. Why didn't you come here?
I'm in the impression that since I'm not having 25 years, I'm not in that.
When did you first file a representation?
I
Yes. How many representations did you submit to the government?
Sure.
Yes, what are the dates?
It's a for the first two. The academic representation.
Annexure 4 is page 1719. Second,
It's a yes.
annexure 10 is legal notice. Legal representation. Dated 1/3/22.
That is next one, please.
Annexure?
Next one, please.
Annexure 20. Page? Guardianship certificate dated
19 March 2020.
Now tell me one thing. When your mother died in 2009, you lived with whom? Who is the elder sister? That much in the name.
Oh. Very.
Mary. Now you see one thing. Your mother died in 2009. No one made any representation for family pension for 10 years. You made a representation for the first time in 2019. They did not give you. Then you went to the court in Senapati, Manipur, asking for a family declaration. For declaration. You did not make the government of Nagaland a party, though your claim was for the Nagaland party. You could have come to Nagaland court and made the government of Nagaland a party. If you had made a government, now how do you how is it binding? How is that declaration made by the Manipur court binding upon the government of Nagaland when government of Nagaland is not a party? And especially when you're not named as a nominee by your father in the family declaration. Why did your father miss out your name? Any reason, any idea? Why? How could he have missed out your name?
During the time of issuing PPO from my mother, there is no provision to.
No. Do you mean to say that your father died before you were born?
No.
When were you born?
There's no.
You see, Mr. Counsel, my grandfather has been in government service. My father has been in government service. My wife is in the government service. I know that there is a family declaration required. I think all the lawyers here, most of them will know that there is a family declaration required to be given. Otherwise, who do you know who is to be given pension, who is to avail of the government benefits? Okay, right.
Prior to 1993.
Now I'm
There is no provision to include the name of the nominee.
What? No, not PPO, Mr. Counsel. You see, when they're serving in the government, they have got to give a list of who their family members are.
As per this
Sorry.
plan issued by the Ministry of Personnel and Administrative, there's no problem.
There is a different.
1996.
Okay, I've heard Mr. V. Sere, learned counsel for the petitioner. Also heard Miss Ina Holly, learned counsel for the respondent numbers. All the respondents. Who is this? Huh? Acha, 1, 2, 1, 2, 1 to 4. And Miss? 12.05. Right.
What's coming, they are not replaced, no problem.
Yes, you get replaced, no problem. All right. The petitioner's case is that the petitioner is the daughter of the petitioner's case is that the petitioner is a disabled daughter of one Mr. N. Lorho Mao, who passed away in the year 1982, while serving as a driver in the Nagaland State Department. On the demise of the petitioner's father, the family pension was sanctioned to the wife of Mr. N. Lorho Mao, who is the mother of the petitioner. White PPO dated 14/6/1982. The mother of the petitioner also expired in the year 2009. Next paragraph. It is the case of the petitioner that she is suffering from 75% disability caused by cerebral palsy, diplegia, DIPLEGIA. As the family pension had stopped in the year 2009, the petitioner, who was the unmarried daughter of Mr. N. Lorho Mao, submitted a representation dated 1/7/2019 to the Accountant General Nagaland, requesting that she be given family pension first up. The petitioner also annexed a copy of a guardianship certificate showing one Srimati L. Mary Mao to be her guardian, issued by the Deputy Commissioner Senapati, District Manipur. Next. The petitioner also submitted two other representations dated 1/3/22. Dated 19/3/21 and 1/3/22. To the Accountant General, Nagaland. No. The petitioner thereafter submitted another representation dated wait, huh? Wait. No. I had two other representations dated so, huh? Both dated 1/3/22 and 1/3/22 and 25/7/23 to the state government and the accountant general stating that she should be given family pension as the family court, Senapati, Manipur, had declared the petitioner to be the legitimate unmarried daughter of the late N. Lorho. Next para. The petitioner's counsel submits that as the family pension was not being given to the petitioner by the state of Nagaland, the petitioner has filed the present writ petition on where is the date? On 10, where is it then? No, 5/9. 5/9/2024. However, during the pendency of the writ petition, the petitioner expired on date 20 September 2025. Next paragraph. The petitioner's counsel submits that as family pension is a property, comma, this court should decide as to whether the deceased petitioner was entitled to the family pension. And if it decides in the affirmative, comma, the property should be the property slash bracket family pension should be given to the legal representative of the deceased petitioner, comma, who is the elder sister of the petitioner. Correct? Subject to the determination to be made by a succession court, by the succession court, by the succession court. Okay, no, right. That's all I think. In this respect, he has relied upon various judgments of the Supreme Court to show that family pension is a property. Next paragraph. Ms. Ina Holi, the learned government counsel for respondents number 1 to 4, submits. What do you submit, madam? Okay. Okay. Submits that in terms of the office memorandum dated 13/7/2015, issued by the government of Nagaland, comma, Personal and Administrative Reform Department, bracket, pension cell, for inclusion of a name as a nominee in the PP book of the deceased pensioner a proper inquiry has to be conducted by the Deputy Commissioner of the district, and after the inquiry is made and the prescribed format is submitted, then only can a person be included included as a nominee in the PPO book after the pensioner expires, to enable the said person to avail the benefit of family pension. She further submits that this court, having taken note of the requirements of the OM dated (13/7/2015) and wide order dated 8/9/2025 directed that the petitioner should undergo the requirement provided in the OM dated 13/7/2015. But that is, however, prior to the petitioner undergoing the inquiry to be conducted by the Deputy Commissioner in terms of the OM dated 13/7/2015, the petitioner expired. So she thus submits that when the provisions of when the required procedure to be followed in terms of the OM dated 13/7/2015 has not been followed, for including the petitioner's name in the nominee of the PPO of the retired pensioner, the pensioner could not be eligible to be given the family pension. That's all. Anything else? What about family declaration? You have not said anything, no? Family declaration, his name is there or not? He has not said anything. There's nothing to show. There's no document to show. Okay. He submits that as there's no documents in the official records of the retired pensioner, of the deceased pensioner, to show that the petitioner was his daughter, the family pension could not be granted to the petitioner. I have heard the learned process for the parties.
My mother's name is Pilgrim.
Your mother's name maybe, but you're not there, nah. Your mother is your mother has been given family pension. That's it. Your name has to be there, right? As can be seen from the records and from the submissions made by the councils for the parties, there is nothing in the official records to show that the petitioner is the daughter of the deceased pensioner. Madam, anything to say? I forgot. Who is approval? Okay, I have to give approval to, for you to give the family pension. Okay, right, huh? Miss? No, forget your senior. Miss Senso, appearing for the respondent number 5, submits that the role of the accountant general comes into play only after the head of department and PNR, head of the concerned department and PNR department gives approval for grant of family pension to a person, to a nominee. Full stop. In this case, as no approval has been given by the concerned department, the family pension could not be given to the petitioner. Anything else? Okay. So what have I said? No, this is pension. Full stop. The petitioner has relied upon the judgment and order dated 20/09/21. No, before that, you just say. As can be seen from the facts of the case, the petitioner's father had expired in the year 1985. Is it? In the year. When? 19. Are you sure?
Next year to 21. And page 47.
No. What is, you don't know your father's death, when he died, you don't know. (1982). The family pension was thereafter given to the nominee of the deceased pension, that is his wife, who also died on 24/2/2009.
Should be 19.
It doesn't make a difference. It doesn't make a difference. We cannot go by what you say now. In your paragraph 3, you have said that he died while in service in the year 1982. Fourth line. Doesn't make a difference whether 81, 82. How old are you now? Or how old are you?
going there, 1974.
74. So right now you are how much? Yeah, 61. Huh? 61. 1974. Okay, right. Where do you get that magic figure of 1974? From where? Where is it reflected in your petition? How do we know your age from the writ petition?
The first certificate.
Page?
Page 16. Page 16. 50.
Issued in 2011. So what is the law regarding birth certificates issued after 3 years of the date of the birth of a person? You don't know. Right, what have I said? Question. The petitioner, for the first time, prayed for payment of family pension on the ground that she was the unmarried ailing daughter of the deceased pensioner. Wide representation dated 1/7/2019. Two other representations were thereafter submitted by the petitioner. That is on 1/3/22. No, that is on. That is on 1/3/22 and 25/7/23. The petitioner also submitted judgment and order dated 20/09/21 passed by the family court Senapati, Manipur in MAT bracket declaratory bracket close case number 6 of 2021, which stated that, which declared that the petitioner bracket 47 years was the legitimate unmarried daughter of the late deceased petitioner. A cursory look at the a perusal of the judgment and order passed by the family court, Senapati, Manipur, shows that the government of Nagaland was not a party to the proceedings. And the only persons who were parties to the proceedings were the other alleged siblings of the petitioner. Next paragraph. As can be seen, continue. In view of the above, it is quite apparent that the family court judgment and order would not, Senapati Manipur, in which the government of Nagaland was not a party, would not be decisive in determining whether the petitioner was the unmarried daughter of the deceased, especially in, unless and until the requirements of the OM dated 13/7 so had been complied with. Also. However, as the petitioner as the petitioner had expired during the proceedings and prior to an inquiry being held in terms of the poem dated 13/7/2015, this court is of the view that the present writ petition has become infructuous has become infructuous. The writ petition is accordingly dismissed as infructuous.
For hearing item numbers 19 and 20.
We put this in the file. Yes, what to do here? Okay, fine. Will you complete? How long will you take? Is the village council necessary to be made a party? You're for the village council. Who's for the village council? Oh, village council is not a party. Have the village council given any letter saying that they will not claim compensation? I don't. Read my deputy position. Case of my report 24 September. Yes. Yeah, yes. Page 2, paragraph 4. But with regard to the statements made in 29 and 12, beginning of the petition, the proponent would like to state hearing that in consultation with all stakeholders, that they aim to have faster development of infrastructure connectivity projects, provisions of extra funds for 2 lane projects in the state,
Nagaland has been chosen, unlike that in other states. The issue of land compensation has been taken up with the respective village council. The competent authorities that represent the village/villager. And accordingly, an undertaking was executed between the parties, duly signed by chairman, village council Meranto, secretary village secretary council Meranto, Meranto village council members, deputy commissioner Magokchong, head Topashi Magokchong, and executive engineer of the National Highway division to Magokchong, and the same has been notarized. Wherein the undertaking, it is clearly stated in the village council of Meranto village, representing the entire citizen of Meranto village, who hereby agree with the department concerned for construction of two laning of national highway in our village jurisdiction, that is so and so. It also undertake.
But the problem, Mr. Council, is that where is his agreement that he abides by the village council village council pronouncement or whatever, the undertaking?
My lord,
How can the village council say something on behalf of him? That is why I'm saying, if the village,
here in Nagaland, we have it. However, we are third of we are entirely too late construction.
no, that is all right. That is all right. You see, the problem is this. The village council has said that we will not make any claim for compensation.
That was in consultation with the state.
Correct. And they have said it by saying that after consulting with all the stakeholders.
Yes.
Now he's saying that no, I was not consulted, and so then what to do?
I don't keep under the law, refer my HOA.
Page
7. Where there is another undertaking. Made by the village council chairman, VDP secretary, around home.
Page?
Page 7, next page. This is true non-judicial board undertaking.
Okay.
If I may not undertaking. We, the village council of Merangon village, representing the entire citizens of Merangon village, we have agreed with the department concerned for construction / new laning of National Highway 2 within our village jurisdiction of this LOC 2. We also undertake that we shall not claim their compensation for any area of land to be utilized for this same purpose. That is so. That is a minimum of 2.5 million. 2.5 million on either side from the center line of the road. That we shall extend all hard cooperation to the department and district administration.
Where is his signature? Where is his signature?
There, man.
Which one?
It's already there.
Where?
On the right side, next page,
Which one?
running page 8.
Which one?
You go to the designation, name, designation,
Which is his petitioner signature? Which one?
it's all.
No, which one? Which one is petitioner's signature?
Here, the entire villager.
No, you see that is the problem. You see, I understand. You understand? I understand what you are saying.
Yes.
Only problem is legally that does not hold. Unless you can show some document or you can prove by way of evidence that he had agreed that the village council would speak on his behalf.
Here, nothing.
I understand. It happens there also. It doesn't happen here only. This is not unique to Nagaland. It's unique to tribal society. Okay, so but then when you come to a court and when they say otherwise, then we have got to go as per the law, not as per our tribal society. This has become a tribal court.
Otherwise.
Anyway, it is a tribal court right now, but then we have got to follow the occupants are tribal, but we have got to follow the constitution and the laws. Can you show some document that he had agreed? That para of page? Okay.
However, wherever the land, such as plantation, fishing ponds, infrastructure such as drinking, shipment of utilities are involved, which are properly assessed by the concerned government and administration, and shall be compensated for its own compensation.
The question is, have this road been made on the petitioner's land? Have you paid him compensation?
Damage or such and such effect.
Where is the payment of compensation? Where is the receipt?
After receiving the delay.
No, you must have some document where he has signed. There has to be some receipt.
Here is.
Where is that receipt?
We can retrieve, however, by now, and exit the state. They are not saying that they have not.
That is why you have to prove them wrong.
And at the same time.
He is not producing the documents, but you should produce at least.
And
No, but then at the same time, where have you stated in your evidence, in your affidavit, that he has been paid compensation? Where have you stated that? In pleadings?
he has no. I have stated in my. If they in a position, we double this number 2, please. The petitioner.
That is another repetition.
Petitioner is something important.
Acha, okay, there's one more.
Because right on the same day, before the conversion to the
Why two repetitions?
They make the keeper, the second is for
Would have done it one repetition.
Number 351 asks go to John. It goes that the first year of 8 lakh.
In which one? In which one?
Page number 63, WPC.
Okay, the 321 you received 8 lakhs. For what?
For the plantation.
For plantation.
Yes.
So you are agreed with what?
There's no evidence for land. And in the first place, no procedure was followed in terms of the National Highways Act or Land Acquisition Act 1894. Notice has to be issued. I should be given the opportunity of being heard. If any objection is to be raised, I have to raise such objection. No procedure at all. And I'm being deprived of my rights under Article 300A of the Constitution. Not sure how can you appreciate. There's no provision under the Highways Act or the Acquisition Act or the Village Constitution system.
Okay.
Yes.
Yes.
One is page 4. There are 5. Next to where? Here.
Yes, yes.
Now, in short, for the same statements made in the end of the petition. Answer to the action state that in this misleading report, as the damage compensation received by the petitioners against these particular stretch of land is 13 lakhs 67,000 198 should be 198.
Doesn't matter. 190 rupees,
And
so
One,
the-
one-
the-
and not one.
he'll return that,
6,000.
he'll return that 682.
As claimed by the petitioner. That's why it is a petition. Previously, on this ground.
No, you see, there are two aspects. First of all, the National Highways Act is applicable in Nagaland. Now. Is it applicable? The National Highways Act of 90, is it applicable?
By recent OM.
2000. And this land was acquired when? Okay, well, is the LA Act of 1894 applicable to the state of Nagaland?
Yes, however, 2013 is not it.
Okay. And we're not talking about 2013. 1894 is applicable. If it is applicable, what does Article 300A say?
Land.
No. Article 300A provides that you can take eminent domain, the doctrine of eminent domain, you can take land, but you've got to pay compensation. And for that, the procedure has been followed. And the procedure is the 1894 Act, according to you. Because the National Highways Act came into force only in 2022. Correct? So 1894 Act was the law that was in force at the relevant point of time. So, has the land been acquired under the 1894 Act? No. That is in violation of Article 300A. No, I agree. What you are saying is that the village council had agreed that no compensation would be claimed by the village. The first issue is, can the village council say that the landowners are not required to be given any compensation? It cannot say. It cannot say on its own because the land belongs to the landowners. If you say that the village council had made the statement or undertaking after taking the permission or as per the authority of the writ petitioner, that statement, that undertaking will have to be proved. That fact will have to be proved. Now, how do you prove that? You have to prove that either by way of some document or by some way of evidence. And there is no evidence to prove that.
Although there was no significant of the land owner, however, they were competent. And the council had.
Maybe that they will say that they were present just for the heck of it. Because the village council wanted us to be present, so we were present. But they never asked us individually if we agreed or not. He's going to say that now. Otherwise, he's going to lose lakhs and lakhs of rupees. He wants lakhs and lakhs of rupees, and so that he can make the village council people also happy. Give them one pig each or something like that. What to do? I agree. That is what happens even in Mizoram. In Champhai district, there was a case. The PWD had made, they were quite smart now. They knew what to do. So they made agreements with all the landowners that this is the agreed amount. So whether the landowners came later on, they said, look, this is done without our knowledge, we are ignorant. They can take land only as per law, not as per their wishes. There's a law laid down. They have to follow the law. Now, what is the court to do? And then some of them saying that, no, we did not make this. This signature is my wife or my son, and this is not my signature. I am the owner, not my wife or my son. And some, like you said, village council had agreed that they will not do it. But then these fellows said, I did not give such permission. Where is the proof? That's why you've got to be very careful. Next time, when you make a thing with the village council, Everyone should sign, name, and they should be witness. Very thick file, but issue very small. So we direct. No, now they've come to this court, it's too late in the day, 2023. This case was filed in 2023. Now, for proper assessment, we will direct the state government to apply the relevant law applicable as per the Land Acquisition Act. And who are the parties for NHIDCL? What to do? How can you see, otherwise you have got to whatever was decided by the state government or by the state, what would you do? Decision taken by state government decision is correct. There's nothing wrong. Unfortunately, they were not careful enough. They should have taken the signature of all the landowners. Correct? It is your land, supposing. Village council is saying that no need to pay compensation. Yes, Mr. Council. So supposing it is your land, your personal land. Village council says, no need to give any, we are not going to claim, no landowner is going to claim. And then your land is prime land, and then what will you say? Without telling me they have done this, you'll get angry. But supposing you had agreed to the village council, then it's okay. Now the problem here is he might have agreed. We do not know. That is orally. Yes. That is not recorded. And now he is saying, no, I did not agree. There's nothing. Where's the proof? Now what to do? If you are cash, tell me some other thing, then it's okay, but there's nothing here. That's all. Why? To do what? To delay the matter. I gave you a hint yesterday or this. You did not take the hint. Time of having meeting. Everybody would present. When the village and partner plantation which have come after all. That is, you see, I agree. And most probably you're right. But people are now getting greedy, no? It is not like the old days where you say yes means yes. Now, yes, but then later on they think, there's no proof. I can change my thinking, I can change. Now what to do? And then when it comes to the court, now what to do? He's a smart fellow, he wants money now. He wants to go to some select city walk in Delhi, South Delhi. He's not happy with the village here, Barabasti market. He doesn't want that to him. Yes. You file a petty application for impleting them. To prove your case. No, no, you can also do it. It is you. He doesn't want the village council to be in the court. Why should he plead? You need them more than he. He doesn't need them. And even if they come, he is not going to say that, yes, I agree. For that, you'll have to go to civil court to prove evidence. But in the writ court, that cannot be decided because it's in one word, not one word, in one sentence, he'll say, I never gave such undertaking. Finish. So, but another implement, though, you have to do it, not him. He's not going to do it. He doesn't know. The court can do it, but why should we take side? Where is the NHIDC here?
See, anyways, they have section by the ministry and it was like implemented the three of the national industry.
Maybe they saw the state is only the implementing agency now. The money for the road was given by the state, by the union.
Yes.
Then
We are only at the very basic party. Union basic party, respondent over.
Respond number one.
Yes.
Who is the respond number one?
The union, Ministry of
More is the party. NHI, this is not a party.
No.
You should have made them party also.
No.
It was the contractor. No? Who was the contractor? You're the contractor.
Yes.
Oh, you're the contractor. Under Mort or under NHI this year? Under the state. And Mort gave the funding.
Yes.
You should have made Mort is the party.
What is the party?
That's okay. So we dispose of the matter or you're going to file an application? I don't know.
Very much direction. See, we're quite just the law.
You have to file an application.
Yes,
You have to file an application.
Relations has nothing to do with those.
Correct. No, you see, it's better. I'll tell you why. The reason being, their entire case is based on the village council undertaking.
I agree.
So once they come, then the order passed here covers everybody. That's the only thing.
Everything will come back.
Even if it comes to light, it's of no use because he's going to deny. The only way probably is for you have to produce evidence. Anyway, correct. Only thing is because he has taken the plea that the village council has spoken for you. And so let them say. And even if they say you can always deny, once they deny, then everything is covered. No, there are no loopholes there. All are covered. All the bases are covered. Even if you plead them, you've got a good case. Just keep that in mind. Because 1894 Act is after. Okay, right. On the prayer, the parties list the matter after the week. You do what you want between that time. Or do you want me to write something? I think there must be some order already written here. Huh? There's already some order written here, no? Wait, let me see. Is there some orders passed? Will you? Yeah, right. heard Mr. Muajabi, learned counsel for the petitioner. Also heard Mr. L.T. Sangtam, learned additional AG for the state of Nagaland, assisted by, no, you're not a senior, no? No. Why should I? You're not a senior counsel. Ms. Apila Sangata appearing for the point number 2, right? Therefore, who's this point number 10? Just say the private contract. Don't say the point number, say the private contract. Right. The matter pertains to the construction of a road by the private contractor under the supervising agency, that is the PWD under the government of Nagaland, on the basis of funds received from the respondent number 1. The petitioner's case is that the petitioner had been given compensation. The petitioner's case is that a road had been constructed over his land without giving any compensation for the land. Compensation had been given only for damages to his crops and building. Crops. First up. The petitioner's further case is that no law has been applied by the state respondents for acquiring the land of the petitioner on which the road was. He accordingly submit that the land of the petitioner should have been acquired and compensation paid under the Land Acquisition Act 1894. Hereinafter referred to the LA Act 1894. Next. The learned additional AG, on the other hand, submits that the land of the petitioner is within the village area of Merangkong village, Merangkong. Merangkong village. Further, the Merangkong village council had made an undertaking to the state respondent that no compensation would be claimed by any villager in respect of the land within the Merangkong village due to the construction of the road by the state respondent. He submits that the petitioner was also a part of the villagers who had supported the undertaking given by the Merangkong Village Council. As such, the petitioner could not now turn around and take a stand that he should be paid compensation in terms of the LA Act 1894. Next paragraph. The issue to be decided is as to whether the petitioner had authorized the Merangkong Village Council to give an undertaking on his behalf with regard to to the effect that no compensation would be claimed by the petitioner. And no land compensation would be claimed by the petitioner. The other issue to be decided is whether that's all I think. Cut that. Once that is decided, then LA Act 1894 comes into play automatically. I tell you right one thing. The learned AG also submits that at the time of construction of the road on the petitioner's land, the only acquisition law applicable in the state of Nagaland was the LA Act 1894. Okay? He also submits that he would like to make an application to implement the Merangkong Village Council. Accordingly, leaves this matter after a week. After 2 years.
For hearing, item number 22.
I don't think, yeah, you want to hear, okay. What is this matter? What is this matter? Huh? Okay, where is he? Where is he? This point number three. Who is medical condition? How do you spell her name? On the request made for adjournment on behalf of the council for the respondent, number 6. On the state respondent, Miss Avitoli leaves the matter after the week.
For hearing, item number 23.
What I have the very fact of the case is that the petitioner was appointed in the year 2018 as a handyman under the partner of the commissioner, Nagaland. And while he was serving, he committed offense of theft, and he was also charged with in this matter, and the criminal case was registered against him. And while the police arrested him in this direction, he did guilty. And in the judge, after the charge was framed at the time of CC, he filed a proposition petition seeking for the benefit of section 3 and 4 of the Office of the Proposition of Offences Act, and
What? He was convicted.
Lordship. He was convicted, but we appealed, and then the dishonorable court was given the benefit to the prisoner.
So given the benefit of doubt.
Yes, with a benefit of the proposition of section 3.
Okay, so he was convicted.
Yes, Lordship. But,
Given his so that Probation of Offenders Act was applied.
was applied to him.
360, section 360.
360 and also section 3 and 4 of the prohibition of offenders. So, during the pendency of this, the criminal revision petition, Lordship, he was terminated, Lordship. So, and in the shortest notice.
What about in the departmental proceeding?
Yes, Lordship.
He was found guilty.
Yes, Lordship, it is the petitioner who pleaded
Guilty. No, what remains, madam? He pleaded guilty. He's found guilty in the criminal case also. What remains?
Lordship, the criminal trial was not, there was not running, Lordship. It can be explained of system, the system.
For that, madam, criminal trial, if you say that there was no trial, then you have to challenge that in a criminal appeal.
Lordship, in fact, it is the petitioner, Lordship. He pleaded guilty, Lordship, before by having the provision of the petition.
Correct. Then what can be done? How can we look? There was a crime committed. There was a DP initiated. There was a criminal case initiated. You admitted in your written statement of defense that you had committed the offense. And in the criminal case also you have admitted that you have committed the crime. Now, what do you expect this court to do now?
The petitioner was being
Huh?
because he pleaded guilty, however, Lordship, there's a fair in this case, also, it was has the problem was the chef and in fact, it was the petition to the city for mercy and also leniency before the department is also before the community for coaching. So, in fact, if the punishment was a major penalty, he was of the I was afraid for the leniency to be
Let us see the memo of charge page
the rich woman and
3-1. Proposes to hold an so under so to so this 9(2) of the Nagaland Services Discipline Appeal Rules provides for what? Major penalty.
But it was the for it was the petition for we did being remorseful of his action. At least the leniency should have been happened.
Madam,
And when we committed the offense, it was only 20 years of punishment. And
Madam, the problem is how can we interfere? Just tell me how I can interfere. If you can convince me, you see, because you have admitted to the guilt. So there is nothing wrong with what has been done. The only thing you could have said was the punishment is not proportionate. But if you say the penalty is not proportionate, the problem is that the Supreme Court has said that if it shocks the conscience of the court, now, you're stealing a vehicle doesn't shock the conscience. I don't want someone who steals vehicles in my employee. You will not want a servant who steals vehicles working for you in your house. Then how does it shock your conscience? Madam, where is the impugn order? Which is the
the last included HATC version. That was the last communication that was given to the petition. HATC initiative. After the curriculum.
No, where is the 26, 26/10/22? Where is that? 26/10/22, the impugned order. Page?
That is just beginning.
Yeah. And did you approach this court earlier? No. It's different. Okay, right. Heard Miss Leonard Counsel for the petitioner. Yes, Miss Mere, what have you got to say? No, that is not the issue here. Out here, in both he has admitted. Okay, right. Heard Miss Mika H.A. Leonard Counsel for the petitioner. And Miss S. Mere Leonard, Senior Government Advocate, appearing for the respondents. Then you take this order dated 24/10/24, this first paragraph. The writ petition has been filed till 22. Okay. Next. The petitioner's case is that a memorandum of charge dated 4/3/22 was issued to the petitioner, whereby two articles of charge had been framed against him regarding the petitioner stealing one government vehicle bearing registration number NL10-4941. Due to which he was charged for violating Rule 4, bracket 1, bracket small 1, bracket Roman small 1, bracket Roman small 2, and Roman small 3 of the Nagaland Government Servant Conduct Rules 1960. The inquiry to be held under Rule 9(2). No, the government also proposed to hold an inquiry against the petitioner under Rule 9 bracket 2 of the Nagaland Services Discipline and Appeal Rules 1967. The petitioner was also asked to submit his written statement of defense. The petitioner submitted his written statement of defense, admitting to the charge of stealing government vehicle and prayed for leniency. Correct? Besides the departmental proceeding that was initiated against the petitioner, a criminal case was registered against the petitioner under South Police Station case number 0029/18 under section 379/34 IPC. The Court of the Judicial Magistrate First Class, Kohima, thereafter summoned the petitioner for consideration of charge on 25/1/22 as a charge sheet under section 379/34 IPC, read with section 7 NSR. What is NSR? National Security Regulation, bracket NSR 1962, had been framed against the petition. The petitioner pleaded guilty at the time of consideration of charge and submitted an application for probation of good conduct, submitted an application for probation under section 360 CRPC, read with section 3 and 4 of the Probation of Offenders Act 1958. Praying for the release of the petitioner on a bond of good conduct as a first-time offender. Instead of releasing the petitioner on a bond of good conduct, the JMFC, Kohima, imposed the fine of ₹3,000 and in default of payment, simple imprisonment for 1 month, while order dated 25/1/2022. Though the petitioner filed an appeal before the Principal District and Sessions Court, Kohima, what is the case number? No, criminal appeal number? Criminal appeal number 1 of 2022. No, not that. That is revision. I said this is revision. No, the Kohima principal, you filed an appeal first, no?
Yes.
What is the appeal number?
Before the sessions.
Okay. Filed a criminal revision, not an appeal. It'll be a criminal revision, petition number 1 of 2022, which upheld the judgment of the JMFC dated 28. No. How can, no, but out here on top you have said that
we appealed before the section and they upheld the judgment.
that is what I want the Sessions Court appeal. Appeal number is what?
Page 46. And even the revision for this.
Oh, so your synopsis is all wrong. Your synopsis come out here. You see, you have said out here, instead of releasing the petitioner on bond of good conduct, the JMFC Kohima imposed a fine of rupees 3,000 and in default of fine payment of simple imprisonment for 1 month by order dated 25/1/22. That's wrong. It is actually 28/2/22. Huh? 28/2/22. Huh? Full stop. Being aggrieved, the petitioner filed. Huh? Wide criminal appeal number 1 of 2022. The same was dismissed by judgment dated 28/2/2022. Full stop. Thereafter, the petitioner preferred criminal revision petition number 1 of 2022, which is pending before this court. Yes, it is pending before this court.
It was petition.
Then now dismissed.
This was not cheap.
How?
This was by washing the document by the JMFC.
Okay. Which was disposed of by order dated. Where is that? 23/5. Disposed of by judgment and order dated 23/5/2023. By quashing, setting aside and quashing the judgment of the JMFC and the first appellate court. However, the case record of GR case number 120, however, her case record of GR case number 120 of 2018 was remitted back to the court of the learned JMFC Kohima with a direction to pass an appropriate order under Section 4 of the Probation of Offenders Act 1958 against the petitioner, as the learned JMFC had erred in imposing a sentence of only fine of rupees 3,000 by not taking recourse to the provisions of Section 4 of the Probation of Offenders Act 1958. Full stop. Next one. The above facts clearly goes to show that the petitioner is admitted to the charge in the departmental proceeding initiated against him. Further, the criminal case has also ended in conviction of the appellant. Yes, conviction. Conviction of the appellant. And that he has only been given leniency. He has only to be given leniency under the Probation of Offenders Act. Puस्तक. In view of the reasons stated above, there is no reason to interfere with the impugned speaking order dated 26/10/2022 and the letter dated 2/9/2023. The writ petition is accordingly dismissed. What to do? Sometimes you get bad. That is very bad case.
For hearing, item number 24.
What is this? You call supervise is required. Oh, let's see. Yes, what is this? Where is that order?
Same obligation only. Approval was obligation for by response.
So this has been stayed, correct?
Yes.
Yes, what to do? You have to give notice, na? So this, he is to be terminated for what reason? Yes, what to do in this case? Mr. Yangawati, are you here? Anything to say? The basic thing is that I think notice has to be issued, no? Prior to taking action. Nothing. Yes, what to do? You tell me, you're the additional AG. Yes, central government advocate. Acha, this is what? Against? Is Yagawati your senior government advocate? No. You're for the government. You're the private respondent. Where is the government? That's what, you're the government. So it's your decision. Court. What do I reflect in your submission? No submission.
My submission is covered in para 3, para 7.
Para 7. State counter para 7. State counter para 7. 7. Para 7? No, para 7 or respond number 6. No, you
Number 5.
number 5.
1 to 5. State.
Number para 7. Para number 7 is not here.
Okay, you will find in state 3.
Just a minute. Affidavit in reply, affidavit in reply. Why do you tie up all this? Okay, this one. Okay, so we'll record this only. So it was not done in accordance with the procedure laid down. But then you have to give him a chance to reply, no? Okay, right. Heard Mr. Moa Jamil, learned counsel for the petitioner. Also heard Mr. Moa Imchin, learned senior government advocate for the respondents number 1 to 5. And Mr. Yangawati for point number 6. Here's the private respondent. Point number 6, comma private respondent. The petitioner, this case is that he was appointed as multitasking staff by order dated 22/2/2024 and attached to the VHC Hankovu. What is VHC? Veterinary Health Center, bracket VHC, Hankvu, HANKVU, comma, under the CVO Wokha, full stop. The appointment was made with the approval of the government and against a vacancy. The petitioner submitted a joining report. No, the petitioner thereafter joined his post in the month of February and has been in service since then. Full stop. The Deputy Secretary to the Government of Nagaland, comma, Department of Animal Husbandry and Veterinary Sciences has, however, written a letter dated 23/10/24 to the Director, Department of Animal Husbandry and Veterinary Sciences, comma, Nagaland, Kohima, comma, conveying administrative approval for termination of the service of the petitioner and for appointment of the respondent number 6 against the post of MTS at SDVO office, comma, Bandari. And so this is order dated 25/10/24. 25/10/24. The first paragraph, that long paragraph. Okay. Next paragraph. The petitioner's counsel submits that no notice has been issued by the state respondents to the petitioner till date. And by the impugned letter dated 23/10/2024, the petitioner service is going to be terminated and the respondent number 6 is going to be appointed in his place. No reasons for the same is forthcoming in the said impugned letter dated 23/10/2020. Next paragraph. The learned senior counsel, senior government advocate for the respondents number 1 to 5, on the other hand, submits that neither the appointment of the petitioner, submits that the appointment of the petitioner was done without taking the administrative approval. No. Submits that, you take this para 7, submits that from neither from the line 3, neither the appointment of the petitioner he also submits that the respondent numbers 1 to 5 leaves it to the discretion and wisdom of this court, to pass appropriate directions as may be deemed just and proper in the interest of justice. Next paragraph. Mr. Gauhati, learned counsel for the respondent number 6, submits that the post in which the petitioner has been appointed and the petitioner's service is to be terminated and the respondent number 6 is to be appointed should be advertised, inasmuch as the appointment of the petitioner was not proper and not according to the rules. I have heard the learned counsels for the parties. The impugned letter, is letter? Impugned letter dated 23/10/2024, issued by the Deputy Secretary of the Government of Nagaland, which is addressed to the Director, Department of AH and VS, Nagaland, Kohima, states as follows. Page 25 of the writ petition, from subject to here. On considering the submissions made by the counsels for the parties and the impugned letter dated 23/10/2024, it is quite apparent that no notice had been issued to the petitioner prior to the issuance of the impugned letter dated 23/10/2024. The next para 7 of the affidavit of the respondent number 1 to 5 clearly shows that, it is to the effect that the appointment of the petitioner and the administrative approval for appointment of the private respondent number 6 to the post held by the petitioner was not made in accordance with the procedures laid down by the government. Para 7 of the affidavit of the respondents number 1 to 5 reads as follows. Next paragraph. In view of the, so you also want you want the notice to be issued, na? Next, on considering the fact that the petitioner has not been given an opportunity of being heard prior to the issuance of the impugned letter dated 23/10/2024, this court is of view that there has been violation of the principles of natural justice. Accordingly, the impugned letter dated 23/10/2024 is hereby set aside with a direction to the respondent number 1 to 5 to first issue a notice to issue notice to the petitioner with regard to the proposed action to be taken against him and the reasons for the same. The writ petition accordingly disposed of. That's all. I think that's all. Nothing else can be done. Pretty late for Nagaland. Huh? Yeah, we are going to have 3 very competent judges coming from first. You have to be ready.